Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
The wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
No, I am not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
All right, he does not wish to be represented. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Thanks for joining me here this morning. Happy Tuesday. We made it all the way to Tuesday. It was doubtful that we'd make it this far. But here we are. It is Tuesday. Oh, man. Good stuff.
Just sent me a video of roaches fighting. I don't know who won.
I don't know who won. Saw the video. No, I don't know who won. I need to find the video. If somebody has that video, I need the link of those roaches fighting. I'm sure there's a couple links out there you could probably send. But I want the ones out of Bayer County. I want the Bayer County roach fight video sent to me. So let me know how that's if you find that. All right. Good morning. Welcome. Happy Tuesday. Good to have all of you here. We are excited. Oh my goodness. Today is an incredible day in the world of true crime, in the world of courts, in the U.S. court system. It's a busy day. It's a busy day. If you can't find,
he's the guy.
If you can't find something interesting to watch today in the world of true crime, you're not a true crime addict. I'll call it right now, because we have the Treehouse murder trial, which is ramping up and getting crazy. We have, I think Murdaugh, something happens today. Sarah Boone has a hearing. It's probably going to be pushed the court date out because they've asked for 3 more dockets down the road. However, how long is a docket? I mean, I was thinking it's like a furlong. Is a docket longer than a furlong? That's what I want to know. Anyway, Sarah Boone's lawyer wants more time. Push that down the road for 3 dockets. Then we've got, let's see, there's Murdaugh, right? Murdaugh's going to be, there's the Becky hearing or something going on in the Murdaugh case. We've got, oh man, there's everything. Like today is the day for courts. Not a ton of like trials going on, but a lot of big decisions to be made right now, and so we're super excited to have those here as options to view. And while we're going to be following the Treehouse trial, it would be perfectly acceptable for those of you who are snooping or spying on those other events to come and update us. And then, if possible, if we get the breaks, we might jump in and just catch the little bits that we missed, just the highlights of some of those other big events, whether it's the Sarah Boone hearing, whether it's a quick snippet from Murdaugh, just all that stuff. So that's where we are. But we're going to be here with the Treehouse murder trial today, and I'm excited to be here with you. Also excited to be here with Kim R., who has the internet firmly in her grubby little fists, because Kim has once again won not just first but second place as well in chat today. Came in first and second. K was first, but High was second. I went with the K. Because that was your first guess. Congratulations, Kim. You know what to do. The internet is all yours. You're an old hand at this, a repeat offender, habitual offender even. So keep it up and running, because everybody needs to know what's happening in the world of true crime today, and we're depending on you. But I know you're capable, so that's going to be great. Big shout out to Happy Hippie, who just gifted 5 memberships this morning. Wow. Great way to kick off the morning. 5 memberships. I don't know where they went. Let's see. They went to Kindle's Life Owen, Sandy Raskin, Jax, McMama, and Laurie Woodman. Congratulations. Let's see. We've got so much stuff. I'm going to go see Judge Boyd in 2 weeks while I go to my follow-up. I'll slide off to see her, and I'm going to ask her about that. Can you send us the video of those cockroaches fighting? Adam Montgomery I believe he's also in court today. Yes, the Sarah Boone update. Unfortunately, I think, Wendy, we know what the update is, and I'll tell you why. We have a new judge, and so this is not Judge Wooten, so he doesn't feel necessarily the same pressure that Judge Wooten does to get this moving forward. Obviously, he's going to look at that and say, yes, we will, but we have a motion by the defense from Sarah Boone's attorney, which is interesting because Sarah Boone's attorney has posted in this motion. I should pull it up. I'm not sure. We're not going to have time because court's going to start in like 8 minutes. But the motion from the attorney is that we need more time. Okay, we're trying to get. He mentioned.
When are we going to break for lunch, Judge?
When we have time for lunch. I'm not sure if we will today. We're trying to get a new expert brought on. We're still waiting for that approval. That might come today. We're trying, and I realize we've got courtroom feet of the wall right now, so we've got everything set up, ready to go. Oh, hot mic in the courtroom.
Friday night, I was completely congested, and I started to panic a little bit.
Have them send someone with more experience.
But then Saturday and Sunday kind of cleared.
Whoa. Okay, we're going to let them figure out their audio issues before we take that live, because that is just nuts. I'm glad I had the peaking turned on so it didn't absolutely destroy us. But they're figuring out the audio. We'll get that started. Anyway, so where was it? Sarah Boone, the lawyer said, we want 3 dockets out because we've got this expert we're trying to get, and she's going to need some time. We've got this expert that was just granted to us just a little bit ago. That was the private investigator. He's going to need some time. Won't be able to be ready by January 29th. And the notes in there that speedy trial was waived. Well, that's not a big surprise to all of us because we've seen that in the list for quite a while. But Sarah Boone has been adamant that she never waived speedy trial on this one. But the lawyer's like, yeah, it was. We've got the record of it. So he says speedy trial has been waived, and the opposition, the prosecutor, does not object. So with that scenario set up, the judge, it's almost like a no-brainer. It's a rubber stamp. Yes, granted. 3 more dockets, maybe 2 dockets. I don't know. He might cut it a little shorter, trying to put some pressure on them. But it's almost 100% sure going to be moved out. But if it doesn't, we're going to know about that today. So that's going to happen. Let's see. Oh, what else? What am I missing? We're doing the navy blue this morning. Yes, thank you, Dale. I'm trying to rock it. I've got these. For those that ask, I get a lot of emails from very kind people who are saying, "Ari, don't look now, but there's a tear in your shirt, right there on the back. I can see it. It's torn." There's actually, I'm not sure if I can show you this. There you go. There's a tear on both sides. This is a ventilated shirt. I love them. When I sit here in the chair all the time, I just want to stay cool, especially up against a leatherback chair or a fake leather chair. I'm not sure which one it is, but they're ventilated on the back, so air runs through here. So this is not actually a tear. It's of course you can't reach it. That would be too easy. But it's ventilation. So when you see that little white slip, that's a mesh that just lets my shirt breathe. Anyway, let's see. Navy blue, ventilated shirt this morning. We're good to go there. All right. What else do we have? I'm excited to be on YouTube all darn day and night. So Sophia Starlin. That is awesome, Sophia. Thanks for being here with us. Courthouse Becky is today. That's a huge one. And if you've been following Emily D. Baker, I'm mostly interested in that case right now. Realize we spent all the time with Murdaugh, right? We spent the entire time. If that case rehappens or has to be redone, it would suck but I think because he's been convicted on or pled guilty to the financial stuff, I think he would. I think it would be quicker because they're not going to rehash all the other things. Hopefully. Anyway, we're going to see what happens there. We'll probably take updates from you guys as you're watching. I'm interested in that one mostly because the judge has controlled in a very unique way media access to this. So anyway, let's see if they fix the audio issues in court. So far it's quiet right now. That's good. We'll come back and check this one as they get ready. I'll leave the audio on, as a matter of fact. Let's see, what else do we need? We have. Oh, did you saw the updates on the what camera is this? 3. You saw this. You saw the updates on our thumbnail, right? I added 2 more things, so hopefully you guys don't mind. We had the blue tarp on the roof, which I might take off, but I put a blue tarp flag, and it's actually a tarp. If you look closely, it's actually blue tarp material So that replaced the red triangle. And then also you guys kept asking about chess. And I found a chessboard that was perfect that I could sit on the table back here. And so I put a chessboard on the table to show that Roger played chess with Matt, as was the testimony when he testified. So those are the two updates I made. Other than that, we might add things. If there are significant things added to the trial, there may not be a lot more, right? Like little material facts added to the trial as far as physical items go. But if there is, we'll see if we can add them to the thumbnail. Had a Montgomery hearing happening as well. Yes, we'll need updates on that in chat and possibly be able to jump and take a quick cut of that. Let's see. Oh my goodness. Is it freezing? Are you freezing? I'm worried because it's not freezing here yet. I will tell you, it's been nice. It's been pretty nice. It's 46 degrees here, which is a chilly start in North Carolina. One of the things we love about North Carolina is we have two seasons. We have summer where it's super, super hot. And then we have winter when the dandelions bloom. It's sort of, I'm sorry, it's just what this part of the country has. But we're expected to get very cold here soon, like into the 20s. Now, I realize you guys, some of you would be like, I wish it would warm up to 20 today because it's that cold. But my house was built out of basically a sieve. It was built out of a sieve, the walls. If you can't see through them, you definitely can hear through them, and you can definitely feel the wind through them. So if it gets windy and cold, my house just turns into an icebox, and no heater can keep up. Let's see. It's Super Tuesday in the true crime community. It's a big one. Oh, man. It is great to be here with y'all. I'm super excited about this. Today's going to be a really fun day. We have some updates. I think we've been hearing some rumors circulating from this court here in Key West that we're following today. Let me go back here. The Key West court. Where's the pickle in the picture? Did you hide the pickle? I have not put a pickle in. I was trying to keep it just true to the court case itself. But if they mention pickles, that's going to go in a heartbeat. Oh, yes. Just in case we're not busy, Rob is having Greg Anderson on his show tonight. I saw that tweet come out. A couple of you guys alerted me to that last week, which is awesome. Or yesterday, sorry. But that's going to be a great watch tonight. If you've got nothing on your schedule, or even if you do, you might want to move it because that's going to be a fun video to watch. Greg is fantastic, and Rob does a great job interviewing as well. Lavender, people freeze at that temperature. Like, that is not that's not conducive to life. I would start looking at options on moving at that point. Okay. Anyway, please stay warm wherever you are, you guys. This is bitterly cold. If you are not able to keep your home warm, if you are freezing right now, reach out to somebody. Please let them know. Give somebody an opportunity to help you out because. Trust me, the world is full of very good people, and people want to help their neighbors. So reach out to a neighbor, reach out to a friend, reach out to family. Let them know the conditions you have. If you're in a dangerous situation right now, especially if you have like a non-standard heating situation where you're trying to use an outdoor heater indoors, things like that. Those are deadly situations, and please don't let that be you. All right. Let's see. So. Recap on Friday. The defendant's trying to impeach the witness who will be returning this morning. Should be interesting. Yes, that's where we pick up. Also, there's a chance of the defendant's witness, the defendant's key witness. What was her name? Paula. Paula is not doing well. She's in the hospital, and we've heard rumors that her health is declining, and even could possibly be declining rapidly. There might be a request to see if they can take this witness out of order over Zoom. That's how bad it is. So we'll see. I don't know if there's a video that's been taken, like a deposition that could be provided instead of witness if she, for some reason, for her health reasons, is not available to testify. But that may happen today as well, or we might hear something about that. Let's see. We have roads in Northeast Ohio are not great today, so work from home it is. That's great. That's great. What brand of chair do I have? I believe my kids bought me this one. It was a Lazy Boy. They bought it from Sam's Club when it was on special. So a Lazy Boy office chair. I love it. It's super comfortable. Who is Rob? Rob, Kirsten, is from Law and Lumber. He's another content creator. He's a full-time lawyer, part-time content creator. Generally, just a nice guy, a really nice guy, very smart, very fun, got some insightful views on just about everything legal related, a lot of legal experience, and just he's a friend of the channel. I think that's my favorite part. He's a great individual. If you go type law and lumber into your YouTube search, you'll find him. That's the name of his channel. He's also a creator in the real sense of the word, because he does woodworking, and he does amazing woodworking. I would show you my pen, but it's in my suit coat pocket right now. He crafted a wood pen for me out of white oak, which is just amazing. The pen, the quality is incredible, and the meaning behind it is awesome as well. But he's just an awesome woodworker. He probably his initial rise to fame in the YouTube world occurred during the Johnny Depp trial, when he did some analysis on the wood, the knife on the bed and the wood and everything like that. His analysis on that and example was incredible, spot on, and that just that's how we found out about him. So it was great. All right, we have birthdays. Quick! Oh my goodness, the judge is going to be here any second. I forgot about the birthdays. Everybody sing together. It's going to be one verse, and then we're going to jump in with the judge here in just a second, because the judge is already late. Here we go. Becky, Andrew, Sophie, all have birthdays today. Here we go. Blend, people, blend. Happy birthday to you. Happy birthday to you. Happy birthday, Becky, Andrew, and Sophie. Happy birthday to you. Wow, I've never cut it so close.
State versus Tucker.
Happy birthday to all those celebrating their birthday today. Thank you for being here. I apologize for
I see the
having the bailiff.
Prosecutors are here, but the defendant is not. My assistant said that he called about 3 minutes ago and says that he's at Lower Keys Medical Center attempting to get the medical information about Miss Belmonte, and is
judge is not happy
en route. So this is troubling. It's an issue that I addressed with the defendant last time he was late. So, not much I can do at this point, other than, did you all receive the materials that you were...
Judge, we received a generalized list Saturday morning that did not narrow down. I think he listed, am I mistaken, David, like a 2-hour portion of the IA interview that he said he intends to use for impeachment. Again, no specific area of the interview other than, I think it was a 1 or 2 hour block.
That is correct. And also on the 12th of, I want to say of this month, while we were in trial, he filed, I guess, some supplemental discovery that he intends to seek to use during his, I don't know what part of his case. I found out about it yesterday because I just happened to check the clerk's website. So I did file a motion to exclude that based on relevance. I filed that motion this morning, but I do have a hard copy for the court.
Okay, well, we will address these things when Mr. Tucker appears.
Very well.
Would you bailiffs let me know when he arrives?
Yes, sir.
Thank you.
Judge is off the bench. Judge is not happy. Judge is not happy. Okay, let me tell you. This is the second time that Mr. Tucker has been late in 3 days of court. Right? We've had 3 days of court, and now we'll keep the audio up. As soon as he arrives, we're going to jump to it. Here's the issue. Mr. Tucker is out on bond. He's bonded out. And I believe the judge has at his discretion the option to revoke bond at this point. And basically to say, look, if you won't show up to court we're going to revoke your bond and we're going to hold you. And then you'll be here on time because our bailiffs will deliver you. This is a problem because probably he's out gathering evidence right now. And I realize if you go back, the judge had asked him to gather this information. He had said, look, Mr. Tucker had made the judge aware of Paula's health concerns and that she was in the hospital, and the information that Mr. Tucker provided was not enough for the judge, and the judge asked for additional stuff. So that is what he's out getting. He's getting what the judge asked, but he's one man. He does not have a team of paralegals or a co-attorney to send out and gather this stuff for him. So here he is doing everything, and one of the things he can't do right now is be in court the same time he has to be in the medical center, because he's in court all business days, and then the business office is probably closed at the hospital, and now he's trying to get these records, which I don't know if he can, because he's going to show up to the hospital and say, hey, I need these HIPAA-protected records for my court case. And they're going to say, show me the warrant. And he's going to be like, don't have one. The judge just said. I mean, you can watch the video. Yeah, you can watch the video, but the hospital's not going to turn things over without a warrant. I doubt this is going to go right. So first, we're going to have the defendant late, and I seriously doubt, unless he gets these records directly from Paula. Paula requests them from the hospital. Hospital gives them to Paula. Paula then gives them to the defendant. I don't think he's going to get them. The hospital they don't play that way. He needs a court order. You can't just roll up and ask for people's medical records. So, all right. Now we need a mad judge lurking in the treehouse and a tardy note. The tardy note might be, I think that's the first thing we might add. She can sign a records release. It's possible, but still, I don't know. Depending on her health, if she's in seriously bad health and is not able to participate in any way in this, he might be. Yeah. If he stops at Starbucks, if he walks in with a steaming cup of extra large grande cafe latte, mocha chocolate latte, caramel, whatever it is, I don't know what his drink of choice is. But if he stops at Starbucks, he's in big trouble, because the judge will see that in a heartbeat. Oh man. Let's see. She can sign a HIPAA release. Maybe that's all it needs. Maybe he's got that in place, but I don't know if he knows that, right? So the problem is he is fighting an uphill battle where an attorney would know this. An attorney would know how to request medical records either through subpoena or through a release. He's fighting the system every step of the way. He doesn't know how to get videos in. He doesn't know how to get impeachment material in. He doesn't know how to get the medical records in, because what he already went and tried to get was not enough. And the judge is like, this is like a handwritten note that says, I'm in the hospital. Sorry. It doesn't work. Let's see. Think he was allowed to subpoena? Yes, he is. Jordy, he fully has that. And usually what the judge will do will order the prosecution to sort of be his subpoena arm. So he fills out a form and says, okay, prosecution, I want you to subpoena this person right here, and the prosecution takes it and says, okay, based on the information you provided me, I can fill out the actual form, work the subpoena properly, get it properly notarized and all that, and we'll have it served by the sheriff's office. But is Paula defense's witness or prosecution? Paula is defense's witness. This is the interesting part of the case. Paula is the only surviving injured victim. Well, other than severely injured, she was cut. Basically, the only person who was cut. Mr. Rogers got punched a few times, and he said that hurt. But I'm not sure if we're going to count those as injuries for this. But Paula was held at knife point, was cut near the neck during this robbery. She survived the robbery, and she is adamant, according to the defense, she is adamant that Mr. Tucker was neither the tall or the short guy in this case, and that he was not there, that he was not involved. What if she dies without saying anything? Is he free then? No, Skybell. We would need that testimony, and it would have to come in some way or another. If she passes away, sadly, if she passes away from her health concerns before she's able to testify, the court may look at other options to allow recorded testimony in. but it's, it would have to be right. It would have to be authenticated. It would have to be in the form of like a deposition or something. And even then, I don't know. I can see ways where it could come through. He got punched through the blue tarp. He did. He got punched into it and was tangled up. But realize, Alley Cat, when you think about him being punched into the tarp and struggling to get out of the tarp, he may have imbibed a little bit on either Bud Light, Captain Morgan, or a wee bit of crack that day. So he might have been high as a kite, and high as a kite trying to get out of being tangled in a tarp is very different than, having full faculty of your senses and everything at the same time. Why didn't he go to the hospital over the weekend? I don't know if the business office would release records over the weekend. A dying declaration. Maybe. At least he contacted the court, unlike Mr. Frog. Mr. Frog, yes, Mr. Frog had a court date. Let's see. I don't know if I have that pulled up. I don't. Good luck. Oral arguments, not that one, not that one. Stevens Coco, that's not it. Okay, I don't remember where it was. But Mr. Frog had a court date that I think was this week or possibly last week that I think he missed. When was the murder? Wasn't this like 7 years ago? It seems like a long, long time ago. Reverend Beasy says hospital records offices are Monday through Friday, 9 to 5, like most offices and banks. And so we've got a holiday weekend. Okay, he's in court till late Friday, then a holiday weekend. Monday they probably didn't do anything for him, and now he's trying to get these records. The murder was 2013. So, oh man, it was a long time ago. Didn't Paula identify him in a lineup as her attacker? Wendy, it's my understanding that Paula says that he was not there at all. Lucifer says, I love that you're now a Canva Pro. Lucifer, thank you very much. I actually reached out to Canva and I said, hey, can I be one of your representatives? And they'll take 6 weeks to decide. Do we know when Paula went into the hospital? I believe it was in the last few weeks. I think it was very close to this court case beginning. G4 Outdoors is admitted to being an addict. Welcome, G4 Outdoors. All you did was click the subscribe button. We call that admitting to being an addict. Welcome. Once you're here, you can never leave, though. We need a clock on the thumbnail. I think we're going to go with a late note. We could add that now as we wait for Mr. Frog. Let's pull up. Let's see, camera 3. What do we have over here? Is it already on the camera 3? No. There it is. Okay. There's camera 3. This is weird because I've got it open in 2 windows, so you're going to see the results, but not me working on it. So, late note. Maybe a tardy note. Let's just search for late. Okay, you guys are not seeing this at all. How can we do this? Let me turn this one off. We'll drag this one over here. Let you guys watch on the screen. Is that all right? Everybody down in front, can you guys see this? All right? Okay.
How does he do that?
Okay, so that was good timing. So what do we want to do for a late note? Something like this one, maybe? Is that... It's like a calendar that shows you're late. Obviously, it would be a little smaller. This would be our defendant. It's got a little much hair for... needs to be a little bigger. know, the clock's just too big. It just doesn't fit.
Don't miss the forest for the trees.
Let's see. Angela says, can't they send them electronically? Here in Sweden, you can send the records electronically. Yes, I think it's getting permission for the records is the hardest part, getting past the gatekeepers. We are going to be talking about Murdaugh and Sarah Boone today, and possibly a couple others, because today is just an incredibly busy day in courts. A post-it on the tree, like a post-it note. Let's see. So you can do one like this. Let's add a text box to it, shall we? It's just going to say late. Let's do it like this, all caps. And now we want this in a different color, probably red. I think red would show up really well. Let's move this down. Need a different font. It has to be like handwritten. What's a pen? Let's see, pencil. No, something thicker. That looks pretty good. Let's do this in bold. Oh, they don't have a bold as an option. Never mind. Okay, that's sort of... Okay, let's grab this one and this one. We're going to group these together. They are now one. They're married permanently. Congratulations. Oops. I don't know what just happened, but not what we wanted. Now we need to shrink the whole thing down.
Have them send someone with more experience.
And tape it to the treehouse like so. Is that all right? So we've got a late note taped on the tree. I need it bigger. Need to ungroup. Hang on. That's not it. Okay, what do we do? Ungroup. Grab the words. Yeah. Meh. I'm not super happy with that, but I'll let that ruminate for a little bit and then see what happens. Let's get rid of this guy. Okay. All right. Is that all right? Did we survive? Post it on the tree. All right. An Alice in Wonderland bunny. You're late for a very important date. This is a very important date. It's no small thing to miss court. Control Z to undo. I'm on a Mac, so it's Command Z, but yes. Let's see. All right, so let's see. It's the wrong scale. Yes, it is. But if it's at scale, it's not going to be readable. So either we switch from a late note to... see. Crystal Ray says, I was just saying to do that to get it to resort back to the original shape and not distorted. Oh, I did sort of skew it, huh? Because I'll fix it here. But I'm not a big fan of that note, honestly. Let's see. So let's do some undos. Undo, undo, undo. Boom. That's where it was last scaled properly, right? So we make it bigger that way. Now we ungroup. Click off it. Let's maybe a different font. Something that we can do in bold. No. Marker, maybe. Oh, permanent marker. One of my favorite fonts. One of my favorite fonts right here. Let's get this one done. And no, I'm not going to do Comic Sans. That's not going to be it. Okay. Let's move it right to the middle-ish, right there. Now group with the other one. Okay. So now we can shrink it down. Does that work? It's a big Post-it note, but it's still readable. Okay. That'll have to do. I'm happy with that. All right, so we're waiting on court was supposed to start at 9 a.m. We're waiting on the defendant. They started actually about 5 minutes late. And then the prosecution was there. Now realize the prosecution has been late as well in this court. So this is not an only offense for Mr. Tucker, but Mr. Tucker has been late. The prosecution was late, and now Mr. Tucker is late again after being admonished by the judge that this cannot be. This cannot be. Let's see. Today is a Super Bowl of true crime. It's sure, if it's not the Super Bowl, it's the playoffs. We've got a lot going on. Let's see. The judge seems short-tempered. How he handles this will say a lot. Is he like Judge Carroll or Judge Schroeder? Right. The judge is weighing his options, and I think he needs to let Mr. Tucker know that revoking bond is one of them. I mean, what's your bond for, right? To show up in court. Is that not, you're agreeing that you're going to show up in court, and not showing up in court would be reason to revoke the bond. And do you forfeit the bond? I mean, that's a lot. It was like a $200,000 that was put up, wasn't it? Let's see. I've got someone calling in. And it's from overseas. Just one second.
Call from
Mathis.
Mathis, how are you doing?
Hi, Scott. I'm doing well. I am a little bit sick, but otherwise I've turned up all the heat in my apartment, and it's going really well right now because I'm buried under a lot of blankets.
Okay. Do get better soon. What's on your mind?
I wanted to use this short break in the programming to talk about the time I ghosted you yesterday.
Okay.
If you don't mind.
Yes, go ahead. That would be great. I got your explanation already. I appreciate that, but go ahead.
Okay. So for the record, I literally got a call from my boss and he was responding to something I had been chasing all day, so I literally had to jump basically. But I wanted to explain this J-Hatch appeals thing that I raised.
Okay.
Basically, when they appealed in 21, the oral arguments before the Florida 2nd District Court of Appeals are recorded on YouTube, and they have their own YouTube channel. And if you look at this case number, which has also been posted on the Discord.
That's the 2D213869.
Yeah, exactly. That's literally just the title of the YouTube video that takes you to the 38-minute session where the two opposing sides argued before the various this trifecta of judges.
Okay, so this is it's not current, but it gives you an insight into basically what their argument's probably going to be.
Yeah. So it is arguably old news, but so because yesterday there was nothing else to watch, I brought it up, and I think it's still interesting for a number of reasons. So the reason why this was even brought up to begin with is J-Hatch really didn't like that the idea that the Kowalskis would be allowed to ask for punitive damages.
Mm-hmm.
And from a defense strategy perspective, you always have to worry about a scenario where compensatory damages gets tripled. And now you look at what they had initially asked for, which is 50 million compensatory, and then let's triple it and add a number 150 million. That didn't happen in hindsight, obviously, but nobody knew that in 21.
Right.
And if you look back at the oral arguments that Altenborn made on December 15th, he was also arguing, the punitives, they were so bad, we need a whole new trial. And so they're obviously still upset about that. And the interesting part is also when he goes through the directed the argument from directed verdict and punitives, we become really interesting if you have hindsight on what has been argued in the past. So, for example, on the unwanted hugs and kisses in the chapel, the reason why there were no punitives for that battery count is actually because there was no connection to tie that to any hospital, like top executives, management, etc.
Right.
And then Altburn, well, since you didn't allow punitives, now you have to also find that the conduct wasn't egregious. And so there's lots of interesting lawyerly arguments that don't really stand up to scrutiny for regular people, but that's the type of argument people are making. And the one thing that I find very interesting about the context for this video is, so in 21, the defense asked Dashkal for two things about the punitives. They wanted to know very specifically, one, which high-ranking hospital employees were tied to these allegations, right, because you need a high-ranking employee to in order to award punitives against the corporation. And two, right, why are the accusations even that bad? You have to spell out specifically why it is that bad. And then what happened in response was the plaintiffs filed something that they wanted to say, we want to amend our complaint, and they're adding a paragraph basically, because of this is egregious misconduct with wanton disregard, so law speak, we want punitive damages. And we want this for every claim, because you ask for everything you can get. And then Judge D, they have oral arguments, and he says, okay, I give you punitive damages on two of these claims. And then he does something with the plaintiff's complaint, which is called interlineation, where he basically adds the paragraph that they want to add on everything, and he adds them to two counts. And also he explains, hey, here, so if you're asking basically for a directed verdict in punitives or summary judgment, okay, I'm going to take all the allegations in the light most favorable to the plaintiff. And so this, here's why this is bad. Here's why you could, here's why there's a reasonable basis for punitive damages. And then the defense complained about two things. Again, one, when you wrote about the conduct being egregious, you didn't always use the language along the lines of, by the way, this is all hypothetical and not prejudging. So they said he did prejudge it, and therefore he needs to recuse himself. And also, you can't just rewrite the complaint for the plaintiffs. They have to file a new amended complaint. Yeah. You can't just interlineate. And so that's why the trial that was supposed to go to trial in May of 22 was delayed to September of 23. And so they filed a writ of what's called a writ of certiorari, which means basically take the papers that we have in this court and send them to the higher court and have them review it right now, because you're deviating from the progress. Yeah, you're deviating from the process so badly, this cannot go. So the reason why this video is interesting, so I'm at the end of my little speech. I don't know
this is the end of your TED Talk. Okay, go ahead.
I don't know if you've seen an appeals court before. It's very different, but it's kind of like all these sentencing hearings, because the judges kind of have written, they have read everything else, and they've written down questions they want to ask. And some of the arguments that are brought up here are actually very similar to the arguments that the defense was still making in 23, or arguably 24, by the time they were arguing about the verdict. Yeah.
We've got to cut it short. We're cutting it short.
I know.
Judge is back. Thank you very much. I appreciate your insight. Thanks for the insight. I've got the video pulled up. Thank you, Mathis. Bye-bye.
What's going on?
Your Honor, I actually did call the court. I was at the hospital with Miss Bellamont. I filed an emergency motion because may not be here to testify on Thursday. She may not be, not only not able, may not be able at all. I was there waiting for the primary physician. I called your office with about a half hour left before court. I could have made it here in time, left my number just so that I could get the advice from the court. But I tried to get...
I'm not so sure why that couldn't have been done over the 3-day weekend.
Because the primary care physician wasn't there, Your Honor. I have no say in his schedule. But I did go in this morning. He actually, last I checked, He was writing it after I left because he was with a patient. That's what I was waiting for. But he went ahead and wrote the letter that you required. And I also asked that he leave a contact so that Your Honor could go ahead and contact him directly. But her situation has apparently gotten critical. She may not be here till Thursday. Be here on Thursday or Friday when she would be potentially testifying. If Your Honor would look at the motion, it's explained in there.
Well, okay, that's not my first priority. I'm not sure what motion you're referring to. Well, what is the nature of the motion? What relief are you asking for?
Your Honor, that's exactly what I was just explaining. She's critical. She may not live till
you
Thursday.
explained her condition, but you didn't explain the relief that you're...
No, the relief's in the motion, Your Honor. But what it is really all I'm trying to do is accelerate the Zoom hearing that we had we talked about and be able to hold it immediately today as opposed to putting it off till Thursday or Friday.
Yeah, I'm not going to address that right now. We'll get to it. Right now I'm going to address what I said I was, and that is the discovery or the impeachment material.
Yes,
so did you get the impeachment material that you were intending to use in order to provide?
Yes, sir.
Okay. So, State, have you received materials from the defendant?
Judge, we have the materials. Again, my objection is the defendant said any or all of this 2-hour-long IA interview. And again, I'm asking for what portion, what's the inconsistency he's going to impeach, and what portion of that interview is he going to use to impeach it?
Okay. So, Mr. Tucker?
Your Honor, it's impossible for me to say exactly everything I'm going to try and impeach when I haven't finished with my questioning yet. There's no way I could tell him that. I mean, if she doesn't say something inconsistent, then I can't use it. I mean, it's that simple. I can't exactly say all I'm going to use, but I did limit myself, which I don't think I had to, but I limited myself to those things that I gave to the State.
Well, it's most extraordinary that someone would think that out of a couple hour, however long it is, tape, that it would be virtually all potential impeachment. I mean, attorneys are expected to be able to provide the opposite side with as specific notice as possible of what they intend to use or believe is impeachment. So
I did do that, Your Honor. I just didn't point to specifics in each testimony, which I don't think the State's going to do either.
So how would you gentlemen like to proceed? I mean, I remember speaking on Friday that you almost anticipated that I would have to view the entire thing. And so that's one of the reasons we're here and put the jurors off until 1 o'clock.
Yes, sir. Judge, let me just apprise the court. The defendant emailed us Saturday morning at noon, which was the deadline, and he said, I plan on using as follows: interview room tapes 1 and 2, IA tape multiple sections. And again, I would ask, we're not going to sit and play a 2-hour IA tape, so I would just ask for what's the inconsistency and what portion of the IA tape. I mean, our witness is coming back in today. We're in the middle of cross-examination. We're going to pick up with where? Where do we start? Is he going to try to impeach her right off the bat? Is he going to begin questioning her? Is there already something he feels that he has the right to impeach her on? I'm just not clear where we pick up from today.
Mm-hmm. Yeah, I mean, Mr. Tucker,
Your Honor,
when the witness is coming, you have to be able to cue this up and present it. We're not going to have what we had on Friday. We're not going to. That's
no. I understand, Your Honor.
People back and forth and waiting anymore. So you have to be able to identify what it is you intend to use.
Your Honor, I have identified exactly what I intend to use, and the state should be well aware of all of that evidence since it came from them. So they should have already examined it. They should already know what is potential impeachment material. Just like they don't tell me exactly what they're going to use, they just tell me which exhibits they have.
Well, sir, simply because something's provided in discovery doesn't make it admissible, nor does it mean the state's committed it to memory, nor does it mean it constitutes valid impeachment material. So
I understand that, Your Honor, but I don't know what I'm going to use until I'm finished my questioning, Your Honor.
Okay, well, let's start with the first part. I mean, again, if I have to sit here and watch the whole thing, so be it. But we're not going to have a situation where these jurors are made to wait because
I have no problem with that, Your Honor. You know, I have absolutely no problem with that. I have a flash drive that was part of the problem, is just the interface with the technology. I can't exactly plug my laptop in there. I found that out on Friday. Okay, so now that part I have no problem with. I also have no problem with using any of this impeachment material and definitely saying how I'm using it while I'm in the process of questioning the witness. I assume that is customary usually.
No, right? This is completely not customary.
No, I mean it's customary to ask a question if she makes a misstatement, or if she for lack of a better word, lies, then that's when I bring out a tape.
Okay. Well, again, I got to. What else are we going to do other than to see the thing? And so that's what we're here for. So let's.
I mean, if you would like an example, I could give you one.
No, I don't want a kind of sort of maybe. I want to see this and make rulings, because otherwise I don't see where we've made 1 inch of progress from Friday afternoon.
If I may.
Yes, sir.
While I am not an attorney, and we've all made that clear, the thing is okay, the state is not going to tell me anything of any of the evidence that they plan on bringing in until they bring it in, right? They're not. They give it to me the same way. They give it to me in bulk, and I have to go through it and decide what I think they're going to use. Well, I imagine they're the same way.
No, sir. Have you ever seen a prosecutor in 27 plus years of doing this that doesn't have a very clear idea and presents it clearly? Yeah, sometimes there might be some little snippet or something, but not where there's apparently hours of tapes that they are using, frankly, very inartfully.
Okay, I'll tell you exactly one that I plan on using, and it's the hours-long tapes that they're talking about. There's 2 of them, the interview room tapes. Mm-hmm. Those I'm using to impeach the fact that she said specifically that I wasn't named a suspect till the 22nd, and I was named a suspect because of the testimony of John Travis Johnson and Rory Wilson. Those 2 hours worth of tapes, that's all they're discussing, is me being a suspect.
We're not going to have that. I mean, you can show me, but we're not going to have 2 hours worth of tapes that somehow or other impeaches a minor point. So
no, and I would actually fast forward. I do have the timestamps. I can fast forward to each section that applies to that witness.
Okay, well, let's do it then.
Well, Your Honor, if I might, I'm definitely willing to do that. I'd still like to address the other issue.
I'm not going to address it. I will address it when I'm ready to address it.
No, I was just.
This session, Mr. Tucker. You're starting to stray from the basic parameters here. I set this session for this issue, and that's what I'm going to deal with. And if Ms. Belmonte is unable to, we will deal with it. But if she's unable to testify, then we have these deposition to preserve testimony. But one way or the other, I will deal with this once I deal with the issue that I've set.
Okay, so I'll tell you what, I'll just play the tapes.
Mr. Tucker's frustrated. The judge is frustrated. I believe the prosecution's frustrated. This is a rough start for the morning. Booting up the computer. You need a power cord. You need a jump drive. The issue that Mr. Tucker wants to address is about Paula. It's all about Paula. It's saying, what's her situation and how can we get her testimony in right now. I don't know if Mr. Tucker's concern is that her health is so bad that she won't be able to testify later, or if he says, I need this testimony in so I can use it to impeach the current witness, which I think I'm getting. Thank you. Thank you, Judge Boyd. I'm getting the impression that he wants Paula's testimony to impeach the current witness. I don't know. That's just the vibe I'm feeling right now. I'm not sure if you guys are getting that as well. I think his glasses may be like the ones that change, that they're tinted when it's bright and when he's outside. So I think they're actually readers as well. They're tinted readers. Wow. It's very difficult to represent yourself. It's very difficult. I would argue that it's very difficult to represent a client. Being a lawyer, if it were an easy job, all of us would be doing it, right? There's a reason it takes a lot of school. There's a reason it takes all this practice. And there's a reason why you have an office with staff that help you with this. This is not something that you want to take easily. You don't just wing it and throw yourself in at the last minute. The state is playing as if they can just roughshod over him as pro se, and the judge is letting them. I do feel that a little bit. The state is not giving him any grace or space for defending himself as pro se. The judge initially was, but I think the way the state's playing, it sort of ties the judge's hands a little bit. They're not giving an inch. According to Mr. Tucker, the way the state turned over evidence to him was just in bulk, and he has to just dig through it all. And he's like, well, I was going to do the same back to them. And he's like, that's not how it works. There may be some truth to that Mr. Tucker would say, actually, yeah, they did just dump evidence on me and say, yeah, we're going to use stuff from here. And he's having to dig through it, which is not very fair if the state's requiring him to be a little more specific. DNB, thank you for gifting a membership. That one went to Kate Manning. Congratulations, Kate. You recognize right away. Toyo Toys, member for 9 months. Can we get someone with more experience? Are you volunteering, Tayo? Oh, here's this. Any chance we can get you on the live stream? If I do a little StreamYard, send you the link, what are the chances we can bring you on the show and interview you? Because you've got some interesting takes on a lot of different things in true crime. Mostly I want to know how you do it. I'm curious about your setup. Let's see, this is why you have a lawyer. A lawyer would have been able to identify the potential impeachments of the witness's testimony and say that the tape at X time addresses this testimony. Culparistic, yes. The judge is frustrated. The Tucker thinks he's just going to play the tape. I don't think the judge is just going to let him roll 2 hours of tape here. Case seems dirty. If what Mr. Tucker says is true, he had nothing to do with this. And you've got two people who were guilty who tried to point the finger of blame at him, either to help him get off a little bit, to help their case, say, I wasn't the one who did this, he was the one who did it, lessen the case for me. I don't see like police. I haven't seen yet any evidence about police involvement that makes it shady or dirty. Of course, that might be what we're getting to right now. There have been firings in law enforcement as a direct result of this case, says Becca Lynn. Well, we know that the witness...
That's why I'm trying to do this now, so we don't have this sort of delay.
You have to forgive me, Your Honor. I was concentrating on Miss Belmont.
Ali B from Tennessee says, thank you, RA Mods and chat, for making this amazing community. Thank you, Ali B. Would not be the same without you. Thanks for being here. 8 months. The courthouse is about to go orange.
Yes, it is.
It's at 9 months, right? Or is it 12 months? No, it's 12 months of orange. You're stuck with yellow for a couple more months. Do they have proof that he did it? I have not seen the physical proof yet. We're bringing the court AV tech.
So I don't no, I don't operate that equipment. You're saying that you need the assistance of Terry. Is that what you're saying?
Actually, I would ask for it only because I don't want to mess with her.
The judge is frustrated. He's going to call for IT.
Let's see if he's here.
The defendant, I believe the TV you've got right there is actually, it has a mini computer mounted on the back of it. By mini computer, I'm talking like a little box that's a little bit larger than, say, like a Roku device or an Apple TV device. All those sunglasses need to go. They are sunglasses. Thank you. Anyway, it's got a little computer on the back, so he's trying to make sure he uses it correctly.
Yes. Thank you.
I realize a lot of you are saying there's a lot of issues in this case in the background. We have to bring those issues into the trial as evidence or argument or as impeachment stuff for that to be considered. Otherwise,
doesn't matter to me. I mean,
the jury has no clue.
Just said I would. I mean, there's cannot imagine that there isn't some specific portions of a couple hours that can't be honed in on, but be that as it may.
It's a discussion at length.
Well, that would be hearsay. That would, I mean, there, you know, if there's some statement that was made, that's one thing. But a discussion between various parties is not impeachment, sir.
The statement that you did not know that the investigator, that I was a suspect until the 22nd, when you had a couple hour-long conversation about it on the 20th. That is impeachment, Your Honor.
Well, sir, you can claim it is, and I make the decisions, and it might be admissible in some form and not the other. But you think you're going to anyway play it, but you're. I understand. Yeah, good. I hope so.
And I understand your frustration.
No, sir, you don't need to placate me. Just do the business. I'm tired of all the extra fluff. Do what you claim you're going to do. Otherwise, you're not going to be able to.
I'm waiting for
which you should have had arranged. Again, if an attorney did this, it wouldn't even be close that I wouldn't have put up with it. I'm bending over backwards to try to facilitate you who doesn't really know what you're doing, and that's not a surprise, but you have the right to represent yourself, but you don't have a right to delay things or to attempt to, you can attempt to, but to admit things that aren't admissible. So in any event, this gentleman now needs one more time some assistance in operating the equipment. So could you give him a hand, please?
Wow. That seems a bit much.
Thank you, sir.
Alicia, thank you very much. Good to have you as a member. That seemed like the judge went a little too far. The whole, this is why you have an attorney. If you had an attorney, if he's mad.
I'm sorry, I can't. Could you pause? What was it?
Here in charge of internal affairs, 2019-42.
Audio or video?
Got it.
I can't see.
I don't think the judge.
No, apparently the court reporter has a question. What?
Is it audio or
I just wanted to know if it was a video or an audio only.
This one is audio only. Actually, all the other ones are video, but it's only audio. You see a blank interrogation. So yes, they're all audio. Be specific.
This interview is being conducted at the Monroe County Sheriff's Office. It's the Sheriff's Conference Room. and it's taking place on May 8th, 2020 at approximately 1 p.m.
I'm trying to close my email. Just give me 1 second so I can give you more information.
No problem.
Okay, please tell me when you get to the part that you want to use, because all of this would not be. No, I don't.
In regard to what's commonly known as the Treehouse murder that took place on November 17, 2017, and investigation in regard to the management handling of the case investigation.
All that stuff is completely inadmissible.
Esquire, who's a representative for one of the defendants in the case of Franklin Tyrone Tucker. Danielle, for identification purposes, please state your full name and spelling.
My name is Danielle, D-A-N-I-E-L-L-E, Malone, M-A-L-O-N-E.
Okay, and what is your present rank and duty assignment?
I'm currently assigned dispatch as a communications officer.
Okay, and this interview will be recorded. Is it being recorded with your full knowledge?
Yes.
Also present at this time is Inspector Donnie Barrios, Montgomery County Sheriff's Office, Internal Affairs. And ma'am, if you could introduce yourself, please.
My name is Krista Mena. I'm staff counsel with the South Florida Policemen and Bar Association.
Thank you. Okay.
Another male that was much skinnier than Detroit that we were looking for.
And of course, one call 911, I believe.
Yes.
Okay. So eventually, Franklin Tucker was identified as a suspect.
Yes.
How did that come? How did he get on the radar?
Well, his name first came up was when he put the Metro PCS name, just because he was with Rory, and then he was.
It is not.
That's all hearsay.
Well, I mean, I understand, but this is apparently the first part that he actually wants to use, where she said his name first came up with the Metro PCS stuff, and I could have swore she testified.
That's exactly what she testified to.
She testified that I became a suspect because of Lori Wilson's testimony and Travis Johnson's testimony. I just went through it the other day.
Sir, she testified to that. That is not impeachment.
If I'm wrong, Your Honor, then I'm wrong.
It's not impeachment. That she said that.
Also living with Rory.
Okay.
And then he got solidified as a suspect.
If you guys want to sit over here in the jury box or wherever.
Honestly, his interview and John Travis Johnson's interview.
His interview being Tucker.
Yeah, being Tucker.
How did that?
Well, some of the things like that he said that they all used, I believe they all used John Travis Johnson as they were with him going to buy cigarettes at some point during that night. So they linked them. All of them linked them.
That also brings up my point, Your Honor. I haven't asked some of these questions yet either. Right? So I don't know if I'm going to be able to use this yet or not. But now I'm playing it for the state. They could have, again, talked to the witness, whatever. But I mean, if they know what I'm going to, if they know what potential impeachment material I'm going to use or exact impeachment material.
And again, I'm familiar with this interview. I understand what you're saying. My specific question is, what is the inconsistency that he claims she said on the stand, and what portion is he going to use to rebut? That's my only question.
Can I say what her answers are going to be to my questions? No. So how do I tell you?
When we broke on Friday, Judge, we were right in the middle of, he was attempting to impeach her.
One question. That's it. Right? One. Not all. One.
Okay, in any event, you know.
I can keep playing it if you want. It's just, again, the witness isn't here. You can keep going if you want.
themselves together, and they're trying to distance themselves from the crime.
Did the video, I know you mentioned video from the motorcycle place, or any other video establish the identities of your suspects?
Yes, the video from the Marine place. I don't remember what the name of it is, but it's right next door to
Cosby's Marine.
Okay, yeah, that'd be it.
Yeah.
It's right next door to the Treehouse. When we finally got access to that, we could see on the video a dark colored truck circle the Treehouse. Then there's a break, and then the dark colored truck comes back, parks almost right in front of Cosma's, whatever, the Marine place, and you can see two people walking away from the truck, and based on the way the one subject was walking and everything about him is built because of how big he was, that was going to be Detroit. And then the other one, his body type and everything matched Franklin Tyrone Tucker.
Okay.
I'm sorry, we can't speak over one another. I'm asking where's the impeachment, if that's supposed to be impeachment.
This is an hour long, maybe an hour long. Hold on, I can tell you in a second. This is how long tape. She actually has asked about this more than once. And okay, just in this one alone, she says, yes, this verifies it, this tape verifies this, which we established at length on Friday that no, it doesn't.
And she said as much. She said...
She did eventually.
We stopped the tape right where she says, Travis Johnston, what we see in the video matches up with what Travis Johnston told him.
She readily acknowledged that she can't see faces. Good. She puts things together. This is a piece of the puzzle, sir. So if you think that, Mr. Tucker, once again, you are deteriorating into interrupting. She doesn't say she can now see the faces. She is putting the evidence together. So there's no impeachment there. Yes, sir.
I don't mean to interrupt.
Well, you do constantly.
I was trying to
but we take our turns, and you don't seem to get that. We talk one at a time because it's polite, it's the way to communicate, and it's the way the court reporter can get the information in the record. So in any event.
I'm very sorry.
Okay, sir.
But it doesn't feel like you're listening to me.
Oh, I'm listening very much. It doesn't feel like you're listening to me, but be that as it may, that ain't impeachment.
No, so far it is not. You're correct, Your Honor. But I also said there is additional in this statement. It's not the only time they bring this up.
Well, okay, let's hear it, because trying to avoid the jury being delayed.
I understand.
Matched up to the video that he was the getaway driver that he took off because he got freaked out.
Okay.
And all of it matched up. So.
Okay. Was there any other video? I know there's mention in the reports here somewhere, some video talked about.
There's a video of the outside of Tom Thumb. It's not actually Tom Thumb's video.
Oh, okay.
Tom Thumb, we attempted to get the video. They gave us video as the wrong day, and then we just never could. Every time we tried to get video from him, it just didn't work out.
Did say the night of the incident, I know things go crazy. There's no doubt about that. But do you know if any detective, any road patrol deputy did go to Tom Thumb to see if they could roll back their video?
Me personally, I don't know if anybody did.
Okay.
I'm sure they did, but I don't know if anybody did.
Okay. Now there was another video of two subjects walking towards what's called the warehouses where they live. It's at the corner of 3rd and 4th, I believe. Yeah, 4th and 3rd. By Tony's roof, that area.
Yeah.
Did you see any of that video?
Yes.
Questions?
Okay, what did you see on that?
Okay.
Just two subjects walking, like I believe there was two. They were walking towards what would be Tom Thumb and or the Treehouse.
Your Honor, to clarify, there are sections in here that, again, I haven't asked questions for yet. I don't know if she's going to lie about it. I don't know if she's going to tell the truth. So I don't know whether or not I'm going to use them. There is another section here at 2022 that I'm going to fast forward to because that section believe it's relevant to the question that was on the table.
Is the judge praying right now?
I believe the night of the search warrant, John Travis Johnson wasn't on our radar yet. We didn't have the video showing the getaway driver. And nobody at the scene had mentioned John Travis Johnson yet.
Okay.
Because we didn't know there was a third guy.
Oh.
So John wasn't on our radar whatsoever. Franklin Tyrone Tucker got released that night. Rolling into jail.
Okay.
We eventually get the video showing that there was a getaway driver.
Right there.
And
video showing that there's a getaway driver. That is not a video showing there's a getaway driver.
The video shows a truck pull up, drop people off, and leave. That is what she's referring to. You agree?
I'm sorry, Mr. Tucker. Once again, you're stepping on somebody when they're speaking. That's not how we do it. So, okay, so don't do it. Go ahead, Mr.
The witness is referring to a getaway driver. She's clearly, and she's articulate, she's referring to the videotapes where it shows the truck pull up, drop people off, and leave. That's what she's referring to as. I don't see an inconsistency in this video and what she's saying.
John, if I may.
Yes, sir.
The reason I did step on Mr. Mansfield's toes is because he agreed with me yesterday that we both conceded. You cannot see the truck leave. He just said the truck leaves. No, you cannot see that.
Mm-hmm. Sustain the objection. It's a plausible explanation and interpretation. It's not impeachment. Yes, sir.
Mm-hmm. You don't see the truck leave. You don't see a getaway driver sitting there. You cannot say that there's a getaway driver in the vehicle if you can't see it leave or you can't see somebody sitting there.
Objection sustained. Let's go on to the next.
I'll go and take this tape out then. Or turn this one off. Because the other ones, like I said, I have questions that I want to ask before I use them.
Okay. Well, I guess we'll just, I don't know what else to do other than but please be ready to do so in a, timely manner as opposed to making the jurors wait, because I'm not going to have that again.
Your Honor, and I apologize. I'm trying to be as clear and trying to be as specific as possible. Mm-hmm. I haven't asked the question yet, so there's no way for me to know if she's going to lie or not.
Okay. His argument he's using, saying I haven't cross-examined the witness yet, so I don't know if she's going to lie.
There's still a requirement that we move in a particular appropriate manner and not make jurors wait inappropriately. So I don't know how much more specific I can be, and you're in any event, I'll just leave it.
And I've heard you, and I'm trying to be as I'm trying to accommodate for it anyway.
Well, we'll see. We'll see how it plays out, because so far your notion of what impeachment is a far cry from what legally is. So in any event, so now we've got this,
Mr. Tucker, I did file a supplemental discovery on the 12th. I found out about the speakings. I was checking because I filed the motion to exclude these items. There's 7 items listed. It's a true homestead video from this Paul Belmonte, an IA report, investigation report and exhibits by Mr. Colonel Chad Scabilia, the Montgomery County Sheriff's Office, letter of recommendation. And he goes on to list any and all Montgomery County Sheriff's Office Division of Internal Affairs documentary recordings, any and all Montgomery County Sheriff Division of Internal Affairs documentary recordings mentioned in his deposition, any and all criminal, civil records from civil lawsuits resulting from this case related to any of the witnesses and parties. States the opinion that under the order of evidence code they are not relevant. They should not be very brought before the court of administration.
Okay, so let me start again. I think I've got I think I've got it up to you. I'm just trying to set the stage here that the state received supplemental discovery on January 12th, and so you're not even saying it's a discovery violation, you're just saying that it's inadmissible?
I'm saying it's inadmissible, Judge. I mean, I would just, I guess for keeping things simple, I'm not going to claim a discovery violation, but these are all obviously not related to the facts as pertaining to this case. There are collateral matters of a civil nature. The state's the opinion that under the evidence code they're not admissible.
Okay, so now defense. Go ahead.
I was just asking a question. Your Honor, I did look at the evidence code, and I didn't know I have looked at this. I can't remember things I made mistakes in their summaries. As far as the ones where it is, you know, all discovered materials, all that was left in from my previous attorneys. So that's been in there the entire time. You know, and bringing it to the court's attention now. Now that was again from that. And I also would imagine, yes, depending on what happens during the course of this trial, any of that could be wrong. But whether or not it's admissible depends on the circumstances. I would correct that. That's what I would imagine. Just like we're again, any of this may or may not be admissible depending on what she says on the stand. And, I did go ahead and look at the evidence code, and there were a few things in there. But yes, the documents from the IA reports, those are reports that are standard reports from the police department, and it is in the evidence code that those would be admissible.
Anything further from the state? Well, it's awfully difficult for me to just with one broad brush stroke just eliminate all that. I don't know. It seems unlikely, but maybe there's some nugget in there that could be admissible. It's really hard for me to say right now.
I think we understand where your court is coming from. Our concern is this. I think we've already established Mr. Tucker's confusion that he's not going to play an hour IA interview and the jury's not going to hear it. This is IA investigator, blah, blah, blah. And I mean, that's an hour of hearsay is what that is. And irrelevance, other than if there's an inconsistent statement made on the stand and there's a specific portion that addresses that inconsistent statement, I would concede that it might be admissible. But as we just heard, what Mr. Tucker is perceiving to be impeachment is not. And that's my concern is that, before the jury hears or sees anything, I want to know what he's going to play them because I don't think there's impeachment in there. It's certainly not so far. And before that's done, I'd like to hear what he's going to play to the jury before that attempt to impeachment is made.
I think I can agree to that. Actually, I do. If this all goes through, I don't know. But I didn't plan on playing the entire tape. I gave you the entire tape so that you could look at it and see what I may or may not use.
Just like Judge, it's preposterous to suggest that a truck somehow phantomly drives itself. If a truck pulls up...
We don't need to. I already made a ruling on that one. Okay. All I'm saying is that proper procedure is for the proponent of the evidence to have it honed in to what they believe is admissible in impeachment and to not just keep a jury waiting for an inordinate amount of time while we do something that we should have done before. As far as these materials that were listed as supplemental materials, again, I'm not going to just make a blanket ruling, but to the extent that if there is something that Mr. Tucker believes is admissible before it's offered, we should alert the state and the court, and we'll have to have a hearing outside the presence of the jury to determine whether it is admissible. So that's the court's ruling as to that. Okay, so now have you seen the defendant's motion about emergency motion for immediate appearance? Had you seen that?
Yes, we brought that one out.
Okay, so did you want to be heard on that?
Yes, sir.
Go ahead.
As I told you, I gave my solutions in the motion, but Paula has taken a turn for the worse. It's not expected that she can make it as long as to get to the defense side of things. I did consult with my advisors. They said that it's not uncommon for a witness to go out of order, but that I should alert the court of the circumstances. And yes, Your Honor, I was attempting to get the primary care physician's recommendation for you and his contact information to verify it yourself.
Okay, so you haven't come up with anything in writing then?
I do have a handwritten note by Ms. Belmont as to her wishes. The primary care physician, that's why I was late this morning, and I contacted the court to let them know. But yes, the primary care physician, as far as I know at this point, was writing the letter when I was on my way over here.
All right, so if I understand correctly, that even though we don't have the information documented that she is, to quote the motion, her health is at a critical point, and she, again, to quote the motion, could be eminently fatal. So I agreed earlier that she could testify by Zoom at the defendant's case. Now they're asking that the evidence be taken out of order in the midst of the state's case. So that's...
And I would object to that, Judge. I wanted the court to be aware. She was posting all weekend back and forth with Mr. Tucker. Either one was posting. There were pictures of them together. She was complimenting him, what a great job he's doing. She was laughing at the fact that I raised an issue about him staring at us during the presentation. She announced at one point in one of the postings, I don't know who posted one of them, that she was going to be released today, and she reposted she'd be released today, but she wasn't going to have one of our people sitting in the room with her, as I had made the request last week. So she seemed to be posting fine all weekend long, and then this morning we're told that she's on her, her dying breath. So until Your Honor is able to get more information, I would object it. I mean, we're in the middle of a witness right now. The state hasn't even rested its case yet. So I don't know. This is the reason her testimony was preserved, because we were told she was on her deathbed 6 years ago. So her testimony was preserved. I can't envision why we would somehow rush this testimony in the middle of our case and let the defense present a witness in the middle of the state's case and somehow tell the jury that's not part of the state's case, table that information for the defense case. I just think it would be highly improper and extremely confusing to this jury.
All right, defense?
Your Honor, first off, I am not aware of most of the postings that they're talking about, because I haven't been paying attention to my Facebook. Yes, I did post a picture of Paula and I last night when I was in the hospital with her. And yes, they did inform me that in fact she alerted me in the morning to her condition. I went to the hospital, the nurse there, they verified that yes, her condition is in that state, but I could not, I'm not a doctor. I wanted to know from her doctor for Your Honor, right? Because I knew that was going to be something you would want to see. And yes, I was there this morning. He wasn't there yesterday. I was there this morning trying to get that, and he is now having offered that. Now the state may be mad about her posting whatever, but that doesn't tell you her health. It doesn't tell you that whether or not she's going to.
I'm not worried about her posts. I'm not. I mean, in terms of this issue, if it's some other issue, I'm not worried about the post as far as that's concerned.
If I may finish.
Yes, sir.
Again, I know we have to preserve testimony, so do they. Now, again, I looked at Marcy's law, and yes, she has the right to testify at any hearing. The victim's rights are clear. And all it says is that we have to make, every accommodation we can, or reasonable accommodation is what it says, right? Now, reasonable accommodation, I think it ought to be more than reasonable here, right? If she is that ill, and if the doctor says that, then why can't?
Anything further? I'm hearing about Marcy's law now. I mean, it's kind of interesting because in 99% of the cases, the defendant would be not desirous of the witness, the alleged victim, being accommodated, quote unquote. In this case, is different, which is fine, but that's been brought up.
Judge, first of all, I'm not mad at anything. I want to clear that up. I'm just bringing to the court's attention information I have. I have a job to do, and I'm doing it. So I'm not mad about anything. She's not a state witness. She's not a good state witness. She's on our witness list. What she's going to testify to, we're already aware of it. It's in her preserved transcripts as well. But I don't think anything has been brought forward that would require this court to make those drastic accommodations at this point.
Anything else from the defense?
We've already admitted that it hasn't been brought forward yet, Your Honor, and yes, it is in the process.
All right, so here's what. I indicated that I would allow her to testify by Zoom from the hospital. I used my discretion. I could have said at that point no, but I felt that that was the fair, best thing to do. But at this particular point in time, I'm not going to force the state to, have a witness, adverse witness, called out of order when we have a deposition to preserve. My discretion at that particular point would be to say if she's unable to testify by Zoom, then she can be heard when it's the defense's turn with the deposition to preserve. That's why it was done. I'm not going to force the state to have a witness taken out of order. Yes? Yeah.
But if the primary care physician confirms what the defense is telling you,
yes,
and she is still wanting to testify, as is her right. Again, I mean, yes, we have, and to make it clear in that motion when we proposed her for that, we did the motion to graduate. It was on the condition that she would be unavailable, right? Unavailability, I looked up in the law too. Unavailability means we have made every reasonable accommodation, and she cannot be here.
Yes, sir.
I'm just asking, would Your Honor change his opinion if he has the doctor's note in his hand?
No, I don't believe that the state should be compelled to allow or to have a witness taken out of order when there's another way that witness is able to testify during the defense's case when they want to call her by the deposition. So at that point in time, my discretion is that the utilization of the deposition to preserve. Yes, sir.
I'm not trying to be argumentative.
Well, you are, but maybe you don't think you're trying, but you are.
As the defense, the prosecution is well aware, and they argue themselves. There's a big difference between somebody giving live testimony and the video deposition. And I do think it's highly prejudicial to this case. It's highly prejudicial to the defendant. It is highly prejudicial to our case if that witness is allowed to, again, succumb to fatal injuries and not be allowed to testify. I also think it does go right against Marcy's law. She is allowed to testify at any hearing.
Yes, sir. I understand what you think, and I think otherwise. So that's why the deposition to perpetuate. I was told years ago, we need this, Judge. We got to move. We got to get this done. And lo and behold, now perhaps it's going to be necessary. I was willing to allow her to testify by Zoom. In your case, where I draw the line is to force your opponent to have their case interrupted by this testimony when it can be presented during your case, albeit by deposition to perpetuate. So irrespective of what the medical opinion is, the court's not going to allow this witness to be taken out of order. So that's the...
I don't know if I'm wrong. I may very well do. But I was also informed by my advisors or my attorneys that this is not uncommon. That it is not uncommon to go out of order. That sometimes it's even done for things as such as vacation, much less somebody who may not be around to testify.
It happens. It's true. It does happen. That doesn't mean... I understand what you can't see. I'm not going to force the state, oh, guys, you've got to stop right here. You've got to let Mr. Tucker present a star witness right in the middle of your case when we've got a deposition perpetuate. I don't think that's fair, and I think there's another way that you can get that testimony here. That's my decision, and, that's how I see it. So, unless there's something else, we have more materials to review, or?
Judge, at this point in time, we have a witness coming in at noon. I guess the jury will be here at 1. Again, Mr. Tucker said that he's got other impeachment, but he doesn't know if he's going to use it or not. Again, the court's already made this clear that impeachment is a specific area. It's not a 2-hour tape. And I guess we'll have to wait and see what happens as the witness is testifying and see what Mr. Tucker's trying to use to impeach.
Okay, I've done everything I can to try to make it as smooth as possible. We expect any other witnesses this afternoon, or?
That's the only one we figured by the time the cross is done and recorrected, it's hard to have anybody else really here at that point because we don't know timing. Maybe it would be prudent to have the court hear this IA interview that you keep referring to, Mr. Tucker.
That's not IA.
Not the IA, the light tape or whatever that is.
It's 2 hours worth of tape. Let's do it.
Again,
I can't tell you specifically what I'm using.
Okay.
But she has a second.
All right. Well, then it's pointless then, other than to expect the defense to be able to at least cue in on that part that they believe is impeachment. That's all I can ask, is that you have the...
Your Honor, I'll make sure.
Okay, so...
That's it, Judge, for now.
Okay, we'll see you at 1 o'clock. Or maybe 12:55.
All right. So we come back after lunch to continue. We've got a 2-hour break now in this trial. Luckily, let me just say luckily, other things are happening in the world of true crime. Let's see if we can. I'm not sure. Nicole, are you in a position where you could give us an update on what's happening with Murdaugh? I can see that we've got stuff going on. Let's see. I can see.
Analysis. Covington is the Court of Appeals case from 2000. In this particular case,
they're arguing, but we're deep in the weeds right now of a lot of case law in that one. I'm not sure if Nicole would be able to give us a ring let's see. Huerman, there's a presser for that. Is that the Gilgo Beach? We've got Gilgo Beach. We've got Murdaugh. We have Sarah Boone supposed to be happening sometime. I haven't seen anything about Sarah Boone yet. Is that going to be a thing today? What a day. What a day. I agree the judge seems impatient, but remember the jury's not present. Right. The judge, in the presence of the jury, him doing what he did would be highly improper if he did that today. I think it was borderline improper today, but in the presence of the jury, that would be prejudicing the jury against the defendant. And the judge should be very much a neutral party in there. Just the judge or the trier of the law, the facts, and the jury takes it from there. But Serbian, wow, about time. Linda, unfortunately, it's not going to be time. The motion, the hearing today, we're going to expect the judge to grant them several dockets worth of delay. So it's going to be out for a while. It seems courts are either feast or famine. Mammograma. This is the way it's going to go. I tell you, when this all happens, I can tell you, I'm just going to make a prediction now. Corey Richins and Brian Koberger at the same time. It's going to happen. Those two are just going to be. It's going to be crazy. Still shows prejudice. I think the judge has been a little bit aggressive, but think back to other cases where judges have snapped on people. We've had. I mean, even in the Maya trial, Judge Carroll snapped on someone and then took a break, but he was able to reset and refocus, and then as if it never happened. Get back that way. Jules sent me something that just went public. I don't know. Let's see if there's a posting here. We were expecting something to come out in the Maya trial. Let's see. Sarasota County Court records. Let's do a quick check here. Search for the case. Let's pull up the documents right now. Just 1 second here. Okay, we don't have a date yet in there. We do have some. We have some orders. Order. We have 4 of them. Order denying defendant Jay Hatch's motion for a new trial based on alleged juror misconduct. That was on the 16th. That just posted here. So we've got an order on post-trial motions, an order directing mandatory in-person mediation, an order concerning outstanding sanction requests. Where do you want to start? Should we start with the sanctions, or save that for last? Let's look at the Jay Hatch one. This is just a 7-page. Just give me 1 second here. Let's get the Treehouse put away for now. There we go. Let's use this one. Evangeline Light, member for 8 months. Thank you. Thank you so much for your support. Courtney Cleany, the OnlyFans trial. There's a hearing tomorrow, or does the trial begin tomorrow? That one's going to be spicy as all get out. Oh my goodness, that's going to be crazy. P&W, good to have you here. Welcome. It's been an interesting trial today. We've got a break until this afternoon. Let's see. I think we can just scroll through this one. All right. Let's pull this up really quickly. This is out of new motions that just posted in the Maya trial. Let's see. Order denying defendant Jay Hatch motion for a new trial based on alleged juror misconduct. Before the court, let's see, Johns Hopkins. He's got all the numbers. Plaintiffs responded. Okay, here we go. Because Jay Hatch failed to demonstrate any juror misconduct, the court denies the motion. And then they go through procedural history. So this is the gist of it right here. This, if it will work, right there. That's this whole 7-page document. Jay Hatch failed to demonstrate juror misconduct. Court denies the motion. And they're going through with the scope of which part they think was what. They declined to expand the scope, the hearing, how it proceeded. You've got the case, basically they're just preserving the record of how they got this far. With the spouse, the term the creature comforts, the sharp-edged S's, all of that's in here. But the gist of this one is right there in that one sentence, so we don't need to dig deep into that one. Jay Hatch failed to demonstrate any juror misconduct. The court denies the motion. So let's close that one. Let's bring up the next one, which is the order on post-trial motions. This one's a little bit bigger. It's about 17 pages. Let's bring this one over and make it big. All right. Order on post-trial motions. Pain more intense than childbirth. Pain more intense than kidney stones. Pain more intense than amputating one's limb. This is how it starts. What an intro. The worst pain imaginable. think it could mean worst. The degree and intensity of which most of us cannot comprehend. Pain is so intolerable that the condition is nicknamed suicide disease. This was but a small portion of the evidence presented to the jury concerning the pain associated with a condition called complex pain. They got it wrong. Complex pain regional syndrome, CRPS. Complex regional pain syndrome is what it should be. There's a typo right in the beginning. Who filed this? It's an order. This is the judge that got it wrong. Maya Kowalski contended at the trial she has CRPS and had CRPS when she presented to Johns Hopkins All Children's Hospital. J. Hatch disagreed. The jury was presented with evidence that the healthcare provider said J. Hatch believed she was faking it. And there was evidence that J. Hatch treated her, or more precisely, declined to treat her accordingly. Lady in Gray, court day full of shenanigans, hijinks, and tomfoolery. It's great to be an addict. Lady in Gray, thank you for your 5 months of support. Good to have you here. Wouldn't be the same without you. Appreciate that. The jury learned this failure to treat CRPS will increase the number and severity of duration of the future of CRPS flare-ups. Maya experienced throughout her entire life. In other words, there was evidence that J. Hatch, by its conscious indifference, sentenced Maya to even more extreme, debilitating pain that she will have to endure throughout her life than she otherwise would have had J. Hatch correctly treated her. There can be no question the jury credited Maya Kowalski's version of the events, as the jury rejected J. Hatch's claims that it provided Maya with exceptional compassion and heroic care. The jury rejected J. Hatch's belief that it was Maya's savior. The jury found that J. Hatch on at least 3 separate occasions falsely imprisoned Maya, and J. Hatch on at least 2 separate occasions battered Maya. J. Hatch management knew about this intentional misconduct and directed it, condoned it, and ratified it. J. Hatch also intentionally inflicted emotional distress upon Maya, yet J. Hatch continues with its quest to immunize its conduct, even though that conduct does not remotely result from its call to the DCF abuse hotline or its participation in the dependency court proceeding. The jury was also presented with evidence concerning J. Hatch's egregious treatment of Maya Kowalski's mother, Beata. Based on that treatment, the jury found that J. Hatch intentionally inflicted emotional distress upon Beata that resulted in her death by suicide. So J. Hatch's motion, post-verdict, timely filed, the omnibus 144-page motion entitled Renewed Motion for Directed Verdict, Motion for New Trial, and Motion for Remittitor. The motion includes a 6-page table of contents found at pages 7 through 12 of the motion, as requested by the court. Plaintiffs replied in an 89-page response. This order disposes of J. Hatch's motion. This order disposes of J. Hatch's motion. We're getting rid of that motion with this order. That's what they're saying. It's out of here. Post-verdict, okay, we've got that. An overarching theme of J. Hatch's motion is that it did nothing wrong. Its actions were rather ordinary. The jury rejected that view of the evidence. In this motion, J. Hatch either ignores or minimizes ample evidence of his misconduct, having sat through the entire trial. The court rhetorically wonders what J. Hatch's definition would be of extraordinary action. This little jab there. There was no doubt that the various monetary awards by the jury are significant. Being large, though, does not necessarily mean they are excessive. In almost all cases here, they are not. Where they are, the court has remitted the excessive jury award. So the judge says there's no evidence that they're excessive. Wow. In almost all cases, there might be some. So where they are, the court has remitted the excess jury. Okay, so there is some remitter. Just because the court remitted a few jury awards, it does not follow that the entirety of the jury verdicts were improper or the product of passion. They were not. The reader should not lose focus on this case. That this case was qualitatively and different than most other cases in terms of novel issues, the juxtaposition of the dependency court proceeding, immunities, and vast number of disputed evidence, the parties' conduct in 2016 and 17, damages sought, disagreements between counsel, length of the verdict form, and consumption of judicial resources, just to name a few. That there are more than 4,100 docket entries is proof. The jury invested 2 months' time listening to complex and often very contradictory evidence. They were attentive and engaged during trial, and they asked questions, many, many questions. They deliberated for 2.5 days in the first phase of the trial. Despite the picture painted by J. Hatch's motion, this jury did not go off the rails. For the most part, the court rejects, without comment, J. Hatch's contentions for the reasons explained during the trial, as well as those cited by plaintiffs in their response. The court writes only a few. For the reader's case, when the court writes on an issue, the court has attempted to identify and retain J. Hatch's numbering and lettering scheme, but the court did not always proceed in the same order as J. Hatch's motion. For that reason, the reader should not accept a sequential 1, 2, 3, and ABC. So we've got the J. Hatch's issues affecting all claims. I want to find what the remitter is. That's got to be in here somewhere. 29 through 45 of its motion raises 5 separate issues that J. Hatch contends affected the entire trial. The court disagrees. For the most part, the court rejects J. Hatch's contentions for the reasons explained during the trial, as well as those cited by plaintiffs in their response. The court writes only on 2 of J. Hatch's contentions. 2A, the scope of J. Hatch's immunity. J. Hatch contends the court should have extended the immunity afforded by Section 39 Florida statutes to cover virtually all of its actions while Maya remained at J. Hatch during the dependency court proceedings. This included J. Hatch's decisions without input from the DCF or dependency court to place Maya in a video surveillance room to confirm whether her actions were consistent with CRPS or instead consistent with a psychological problem that may have been caused or enhanced by her mother's behavior, as well as removing Maya's clothes to document her skin condition before she left for court. Parenthetically, note here J. Hatch's downplaying of the evidence to suggest that its actions were benign, contrary to the jury's construction of J. Hatch's actions. Gypsy Moon says, hey, I got my gold courthouse. Thanks for the great place to talk about true crime. And love to my fellow addicts and recovery addicts. Thank you, Gypsy Moon. Congratulations on that 6-month yellow courthouse. Yes, Greeners, the reader. He's talking to us as the readers, not just me specifically. So J. Hatch has no explanation why, if these actions were taken for medical reasons, Maya's medical records were not littered with reports, observations, photographs, and other contemporaneous notes documenting what was being done to Maya and the results of those tests. Certainly, the jury was presented with evidence, and the lack of medical records explaining the necessity to place a commode just outside of Maya's reach and then intentionally delaying and coming in to help her use the restroom, causing her to defecate on herself. If stripping a child and taking photographs was done for medical reasons, where's the concurrent medical record evidence? These are but a few of the cruel acts for which J. Hatch seeks immunity. Well before trial, the court addressed several summary judgment motions based on the scope of immunity authorized by Section 39. The court will not restate here its prior analysis other than to note the legislature in the statute commands good faith for immunity to exist. The court previously noted its concern about the binding precedent of case law that appears to write out legislature's good faith command to secure immunity. But as the court was bound by these decisions, the court followed them and eliminated several of plaintiffs' causes for action against J. Hatch, even without a factual showing of good faith. In addition to the good faith requirement, Section 39 immunity is further qualified by the which might otherwise result clause. Committing intentional torts, performing medical malpractice, and engaging in fraudulent billing do not otherwise result from J. Hatch's participation in the Chapter 39 process. There was evidence from which the jury could find J. Hatch intentionally engaged in these torts and committed malpractice. The court knew before trial where it drew the line, and on allowing and disallowing evidence in affecting the Chapter 39 immunity would be scrutinized by the losing party or parties. As the court repeatedly told the parties, the trial on the remaining causes of action was not to be litigated in the first instance of the issues that would have been tried in the dependency court had Beata not died by suicide, but both sides constantly attempted to do so. On the one hand, J. Hatch objected to and heavily criticized any effort plaintiffs made to introduce matters that occurred in the dependency court proceeding. On the other hand, J. Hatch repeatedly attempted to litigate the core claim from the dependency court that Beata Kowalski had committed medical child abuse on Maya Kowalski and that Beata Kowalski suffered from Munchausen syndrome by proxy. The court, though, had already ruled J. Hatch immune from all claims that otherwise resulted from its agents reporting the suspected abuse. Despite the court's trepidation during trial, the court believes the trial transcript will demonstrate the court routinely allowed J. Hatch to provide substantial and likely cumulative evidence and testimony concerning J. Hatch's theory that Beata Kowalski suffered from Munchausen syndrome by proxy because it gave context to how Maya Kowalski presented to J. Hatch in October of 2016, and it had some probative value on the wrongful death and survivor claims. Plaintiffs objected to the court allowing this, to the point where plaintiffs often complained J. Hatch was using Chapter 39 as both a sword and a shield. The court also suspects the trial transcript will confirm the court extended much more plaintiff's efforts to present Chapter 39 materials than the court excluded from J. Hatch's requests. After all is said, though, even under J. Hatch's requested more generous scope of immunity request, the reality remains. J. Hatch battered Maya Kowalski on at least 2 separate occasions, which actions do not otherwise result from any Chapter 39 action J. Hatch took. J. Hatch falsely imprisoned Maya on 3 separate occasions, which actions do not otherwise result from any Chapter 39 action J. Hatch took. J. Hatch intentionally inflicted emotional distress on Maya Kowalski, which actions do not otherwise result from any Chapter 39 action J. Hatch took. J. Hatch intentionally inflicted emotional distress on Beata Kowalski, which actions do not otherwise result from any Chapter 39 action J. Hatch took. J. Hatch submitted fraudulent bills, which actions do not otherwise result from any Chapter 39 action J. Hatch took. And J. Hatch committed medical malpractice on Maya Kowalski, which actions do not otherwise result from any Chapter 39 action J. Hatch took. Judge Carroll is spelling it out here in bold. Consistent with its "we are protecting the mandatory reporter" theme, J. Hatch continues in the motion with its "sky is falling" public policy argument, which is more appropriate for the legislature. If this judgment is not set aside, no hospital in Florida will be willing to keep a child in DCF custody once the child is ready to be discharged to foster care. Motion at page 34. The court does not understand J. Hatch's embrace of that public policy argument without reference to its egregious conduct this jury found J. Hatch committed. The court concludes the legislature by adopting 39 did not immunize a hospital that intentionally harms a child. The court further concludes the legislature did not immunize a hospital from its medical malpractice or fraudulent billing. The court denies J. Hatch's request to expand the scope of immunity. Pam Jam says, hello from feels like negative 25 degrees in Wisconsin. I have no more nails to bite. Oh boy. Packers 49ers, Saturday, 1:20, 7 o'clock. See Central. Go Pack, go. Somebody's excited about an upcoming tennis match. Just kidding. Football. Prior to trial, let's see, the addition of time. This is another thing he's talking about. Yeah, and when you talk about addition of time, the plaintiff wanted more time. They used it up. And twice they were given more time. Once just plain more time and once with conditions. But the defense is complaining about this. So the judge is addressing this in this motion. Let's see. The court announced that it would be limiting the time attorneys had to present evidence and testimony to the jury, whether on direct or cross-examination. This time allocation excluded opening statements and closing arguments, as well as any legal arguments that were made outside the presence of the jury. The court believes plaintiffs requested 100 hours per side, and J. Hatch requested 60 hours. The court originally sought to allocate each side 50 hours before finally allowing 55 hours per side. During trial, the court made 2 small alterations. The first time alteration occurred before the plaintiffs rested their case in chief. The court awarded each side an additional 4 hours based on the many questions the jury asked. And juror number 1 was not the only juror that asked a lot of questions. There were others too. The court, in arriving at the 55-hour time allocation, had not anticipated the substantial expenditure of time due to the many jury questions, as well as the attorney's follow-up after those questions. And routinely, a second and sometimes third round of additional jury questions with additional attorney follow-up. The court reached its 4-hour award on the court's projection of the amount of extra time each side would have to expend in following up to the juror questions during the entire trial. Thanks, Pam Jams. The court recalls J. Hatch objecting and indicating that it had additional questions for witnesses already appearing, although J. Hatch did not advise the court concurrently that it did. Regardless, the court told J. Hatch that it could call any of the individuals who had already testified if they had additional questions. To the court's knowledge, J. Hatch did not accept the court's invitation to do so, despite having time. The second time alteration was near the end of the case, during J. Hatch's case in chief. Recall cross-examination was included in parties' time allocation. So when you recall and cross-examine, it was included in your time allocation. Plaintiffs identified that they were nearly out of time, and they still had non-cumulative evidence to address, and they had been efficient with their time. The court ultimately granted an additional 2.5 hours for use in cross-examination during J. Hatch's case in chief, which would not carry over to rebuttal. The court also granted plaintiffs a total of 2.5 hours for rebuttal. The court made that assessment based on when evaluated over a 2-month trial, plaintiffs for the most part were generally efficient with their time, especially after the court observed and commented on in real time any perceived slowness. While the transcript, when prepared, will reflect the actual time consumption announced by the court believes plaintiffs used 60 hours of trial time in its case in chief and cross-examination of J. Hatch's witnesses. Plaintiffs also used 2 hours in its rebuttal case. Thus, plaintiffs were 7 hours over the court's initial allocation of 55 hours and 2 hours over what J. Hatch originally proposed. Defendants used 42 and a half hours in its case in chief and cross-examination of plaintiff's main case, and an additional 55 minutes in cross-examination during plaintiff's rebuttal case. To put 7 hours in context, that would be less than 2 trial days before the jury, as the court attempted to have 4.5 hours of court time in the jury's presence each trial day. The court cannot agree that J. Hatch was prejudiced because the case went to the last day, the court announced to the prospective jurors in September. During trial, the court allowed days off requested by the parties and allowed the jury to leave early on other days, based in part on how the trial was progressing. The court also allowed parties to make lengthier legal arguments together with many requests to reconsider. The point is, the court continuously was evaluating the time consumption and was sensitive to both sides' contemporaneous discussion of time needs as they occurred and what the parties were then forecasting. If time truly were become an issue for either side, the court would have trimmed days off, trimmed the length of arguments, worked earlier and longer, and otherwise would have addressed whatever the parties said they truly needed. And if truly necessary, and certainly not optimal, the court would have extended the trial into the following week as a last resort, but the party would have had to discuss the issue in real time with the court to give the court an opportunity to address whatever the claimed issue to be. The court's granting this extra time did not adversely impact J. Hatch, especially when the court gave J. Hatch additional time and allowed J. Hatch to recall any person they felt they needed to further question. Further, the court believes the trial transcript will not reveal J. Hatch contending that they were unable to present substantial evidence that it wished to present due to the lack of time. We've got a few more things. I'm going to start skimming through some of these because this is long. And we've got, let's see, is there a buffer sound? Buffer. Some are confused. Okay, let's see. We are reading some motions. Let's see. Hold tight. We're reading motions in the Maya Kowalski trial. If somebody can put that in a message, it doesn't matter who it is, mod or otherwise. We're reading judges' motions filed today that went public today in this trial. We've got 2 more motions to go through, and they cover all the good stuff, including possibly sanctions. Judge Carroll, period. Yes. Let's see. Here we go. Becca Lynn. We're going to post your comment right here. Pin this message. Ari is currently reading the order on post-trial motions in the Maya Kowalski case. Okay, so I'm gonna go a little bit faster through this one. I'm not gonna read everything. We're gonna skim it. Sophia Starlin, thank you very much, by the way, for your 2 months of support. Wonderful to have you here. Wouldn't be the same without you. He's talking about the Maya Kowalski intentional tort claims. J. Hatch in its motion raised multiple claims concerning intentional torts the jury found J. Hatch to have committed against her. J. Hatch amalgamates all damages for the claimants for all disparate claims into a single number without regard to the separate conduct occurring at separate times and separate counts. By commingling multiple claimants' awards for multiple claims, jury ignores the jury's specific awards by claim and claimant. As it relates to Maya Kowalski's intentional tort claims, the jury found... And here's their findings with the false imprisonment, economic and non-economic, and jack economic. So we've got the different damages for each one. I like this chart. Judge Carroll, you did a great job on this one. And here are our totals. We've got the false imprisonment. That adds up from here. Total of $50 million for the imprisonment and battery. Put into their separate claim text, these numbers do not reflect J. Hatch's contention of an unbridled jury that ran amok. The jury's restraint is particularly observable in the 3 punitive damage awards, which J. Hatch also challenges. The punitive damage awards do not exceed the statutory caps established by Section 768, even though the jury made findings to permit them to be exceeded. Notably, J. Hatch in its Phase 2 evidence and closing argument convincingly and effectively communicated to the jury that every dollar award as punitive damages would be a dollar unavailable for important cancer research or charity care, including care in Sarasota County. This argument resonated with the jury. Given the balance sheet and other evidence of net worth exceeding $1.2 billion introduced into evidence, the punitive damage awards were rather tempered between the need to punish and the consequences on others based on the punishment. If this jury truly were influenced by improper emotion instead of dispassionate evaluation of the evidence, it could have awarded $500 million or more without coming close to bankrupting J Hatch, but it did not. Instead, it awarded a meaningful but not debilitating amount. So it sounds like the judge is very happy with the total, and he's not going to do anything about it. So let's see what happens here. It's going to go down by a little bit, but we'll find out where. While the court is only making a few comments in response to certain arguments, there simply is no need for the court to add to what has already been said previously by the court, by the jury, and by the plaintiffs in their response. Okay. Let's see. Waive the 24-hour claim as it relates to false imprisonment. There was evidence there. Confusingly, J. Hatch contends this process was not actually treatment of Maya Kowalski. It was primarily a non-invasive diagnostic test. This was a running problem for J. Hatch during the trial. Either it was performing a medical procedure or it was not, and J. Hatch was never clear and definitive with that quandary to the jury. If it were a medical procedure, there should have been copious contemporaneous discussions about it in Maya's medical chart. The jury heard and saw evidence there was not. And while J. Hatch says there is evidence she was not imprisoned in the EEG room, where, as here, there is disputed evidence, it's up to the jury to resolve the conflict. As it relates to the battery finding for hugs, kisses, and petting, no means no. Look at that. Boom. The court, though, pauses to note the paragraph of page 81 of my motion to J. Hatch's discussion of battery. J. Hatch asserts, Maya Kowalski claims that Miss Beatty told her that she wanted to be her mother. Assuming that testimony is true and Miss Beatty's testimony is false, that statement is not a battery and did not involve a touching. It would have to rise to the level of extreme emotional distress even to be relevant in this case. This, of course, minimizes Maya's testimony, which speaks to the intentional infliction of emotional distress. Yet J. Hatch discusses it in the context of battery, saying the statement is not a battery, as if to dismiss the conduct in its entirety. This paragraph is an artful dodge of the evidence because J. Hatch then ignores the evidence that J. Hatch purposefully was trying to emotionally alienate Maya from her mother. Telling Maya her mother was dangerous, telling Maya repeatedly that someone else was going to be her mother was wrong. The court understands that the healthcare providers at J. Hatch, to their core, believed that Maya was not safe in Beata Kowalski's presence, and the law permitted them to share those concerns in the abuse hotline report and to the dependency court. They should have kept their actions there. But there was evidence they did not, and there was evidence from which the jury could find J. Hatch's hubris in engaging in conduct to Maya's face that J. Hatch purposefully designed to destroy Maya's relationship with her mother. Let's see. J. Hatch, medical malpractice claims. As the court is denying the various motions relating to Dr. Sally Smith and in consideration of the parties' prior notification to the court, these parties will need to advise the court on the issue of set-off and how set-off will be effectuated for the entry of the judgment. So set-off has to do with the settlement that affected Dr. Sally Smith, right? Because there was already another case that was settled. They settled with the family. So there's going to be a set-off or some reduction at that point. Personal representative of the estate of Beata Kowalski's claims. Okay. The court agrees the personal representative must elect between the jury's award in the survival action and the jury's award in the wrongful death action. They're saying you can only have one of the two. And the personal representative has done so. The personal representative elected the wrongful death claim verdict. Okay, this part is rare. This is why this case is going to be in all the law books going forward. J. Hatch understandably challenges the court's allowance of a claim involving a decedent's death by suicide. This claim is rare. Except in narrow instances not present here, Florida law does not permit recovery for a person's death by suicide to a tortfeasor's negligence. In dismissing negligence theories of liability, the court held Florida law provides that there exists no liability for another's death by suicide absent a specific duty of care. In other words, The personal representative's efforts to hold J. Hatch liable for its alleged negligence associated with Beata Kowalski's death failed to state a cause of action because J. Hatch had no duty of care owed to Beata Kowalski to prevent her death by suicide. That is precisely why the court dismissed the negligent infliction of emotional distress claim. In that same order, though, the court distinguished negligence torts from intentional torts. In refusing to dismiss the wrongful death claim based on the intentional tort, the court explained, the court's analysis in Count 6B of why the personal representative cannot maintain a wrongful death cause of action for negligent infliction of emotional distress does not necessarily apply equally to Count 21B. That is because the intentional count removed the duty element, which was the linchpin of the ruling in Count 6B. So he explains why one was dismissed and one was not. Can we get motions denied for dummies at the end, please? We're gonna try to summarize this because he's explaining his reasoning and the rationale, and I think by the time we get to the end, we're going to see the effect this has. Let's see. The judge is picking through all the motions that were filed here. With few exceptions, the court disagrees with J. Hatch's contentions concerning excessiveness of the verdict. So there are a few exceptions. There are exceptions. The court says there are some areas the verdict is too high. This is where remediator is going to come in. Excessiveness of the verdict associated with damages awarded for Beata Kowalski's wrongful death. The fact that a damage award is large does not in itself render it excessive, nor does it indicate that the jury was motivated by improper consideration in arriving at the award. A verdict should only be disturbed when it is so inordinately large as obviously to exceed the maximum limit of reasonable range with which the jury may properly operate. Florida statute directs the court upon proper motion to review the amount of such an award to determine if such amount is excessive in light of the facts and circumstances which were presented to the trier of the fact. In performing this analysis, the legislature set forth criteria the court must consider. The 11th Circuit's decision provides a good review. Here's where it spells out. Here it is. The jury's non-economic damage award due to Beata Kowalski's death. The jury awarded Jack $50 million in non-economic damages for Beata Kowalski's death. The jury also awarded each child $18 million in non-economic damages. The total non-economic damage award for Beata Kowalski's death was $86 million. The court concludes that no remediator is required in consideration of this section. The court also rejects J. Hatch's efforts to compare this case to tobacco cases under the reasoning of Caravan. Instead, this case was simply different than those cases, and to comparison to them is unavailing. He didn't change it. He didn't reduce it. The court is not stating that this amount... Okay, let's see. Factor D, though, was implicated. It requires the court to evaluate whether the amount awarded bears reasonable relation to the amount of damages proved and the injury suffered. Where an award exceeds the maximum amount which the jury may operate, the verdict should be reduced to the highest amount which the jury could have properly awarded. In doing so, the court is not stating this is an amount it would have awarded if it were the fact finder. Instead, the court simply determines the outer limit of the jury's discretion. So he is going to reduce it here. Let's see. The question of how to compensate the claimant for a human, non-economic loss always comes down to a question of money. The court has heard the arguments on both sides in this case and other cases concerning the propriety of awarding money to compensate for non-economic damages, but Florida law, like the law in other common law jurisdictions, has not found a better way. It's the only way you can compensate is money. You can't, bring them back. The court suspects any claimant that they would rather have the decedent alive, would say they would rather have the decedent alive than with them and with an X or Y dollars. And the court is aware of the age-old discussion of adequacy of the standard of jury instructions on non-economic damages. The reality is the jury is permitted to determine an amount that is fair and just in the light of the evidence, subject to the legislature's command for the court to evaluate it, among other things for excessiveness. And the court's done this. Under these very unique circumstances, the court concludes that the jury could properly award $18 million to each child and will deny the remediator motion for those claims. The $50 million award to Jack Kowalski for non-economic damages, however, is excessive. Here, the highest amount to which the jury could have properly awarded as a non-economic damage award for Jack Kowalski's loss was $24 million in consideration of the evidence. So he dropped it by $26 million. The court, therefore, will remit the $50 million verdict for Jack Kowalski's survivor non-economic damages by $26 million to $24 million. In total, the non-economic damage award for the 3 remaining Kowalski survivors is $60 million in the aggregate. The jury's economic award due to Beata Kowalski's death. The jury awarded $18 million to Jack for this. The jury also awarded the estate $650,000 for a total, and $2 million to each child for a total of $22.6 million. The court concludes that they do not require a remittitor. Let's see, under another clause, they do. As a reminder, remittitor does not examine probability. It's the highest permissible range. Okay, so under the evidence presented to this jury, the highest amount the jury could have awarded properly on economic damages for Jack was $2 million. So they went with $18 million. So he's taking that down by $16 million. So $2 million, and for Maya was 1.7, for Kyle was 1.7. The court leaves the 653. So he's reducing the $18 million by $60 million down to $2 million. So now we have a total of $16 million by twice he's reduced it by, right? That's $32 million plus an extra $500,000 for Kyle and Maya, the reductions there. So we're at total reduction by $32.5 million. The principal will be changing. Yes, P will for real. For sure. Let's see what else. Billing fraud. Okay, this is the one that was going to go away. We knew this one. But this is a big reduction. The court notes the jury and other counts awarded Jack Kowalski a little more than $1.5 million in economic damages associated with Maya's care. At questions 32 and 33 on the verdict, the jury awarded Jack $3 million and $2 million respectively for various economic damages. Of all these issues of the case, the parties spent the least amount of time and attention to this claim, and so will the court. The court agrees. The little more than $1.5 million in direct economic damages to Jack individually received is the maximum amount Jack Kowalski individually could receive for all these economic damages. The $5 million awarded in the damages in questions 32 and 33 on the verdict form exceeds the maximum permissible range, and remittitor is required. For that reason, the court will remit the $3 million for question 32 to $1, and it will remit the $2 million for question 33 to $1. The court denies. So they took the $5 million away, and that's what we expected, that $5 million reduction. But they took it down to $1. It has to be something. So it's a symbolic gesture only. The court denies J. Hatch's motion in all respects except as specifically identified in this order. The court grants certain remittitor motions with respect to only a few damage awards. It is ordered and adjudged. Defendant J. Hatch's renewed motion for directed verdict, motion for new trial, and motion for remittitor is granted in part and denied in part. The motion is denied in its entirety except as specifically granted in this order. The motion for remittitor associated with the $50 million verdict for Jack is granted. The court will remit $50 million by $26 million. Okay, so, 26 plus 16. So we've got 26 plus 16. That's 42. 42 and a half. And then another 5. So $47.5 million. Am I doing the math right? He reduced it by $47.5 million. So we're still over $200 million. 61 minus 47.5 takes us down to 12.5. $212.5 million. Is that just in my head? That's where we're at. And then we still have the set off with respect to Dr. Sally Smith's settlement. So they're going to reduce it. The parties have to advise basically how much they get from that, and that's going to reduce this. This order is not the judgment or judgments and does not complete the judicial labor remaining in the case. The remittitor election periods have not expired, and the mechanics of set-off have not been resolved. After those two issues have been resolved, the court will enter the judgment, if elected by the personal representative Jack Kowalski, individually or both, a new trial on any rejected remitted damage claim. Parties will email the court's judicial assistant one or more judgments in Word format that effectuate the jury's verdicts as discussed in this order. If the parties are unable to agree as to the form of the judgments, each side may present their version. The court requests this directive to be accomplished no later than 2 days after the plaintiffs determine how they wish to proceed with respect to their remediator. So Jack gets to decide if he accepts this or not. So that's the end of that document. We have two more, and they're much shorter. We have an order directing mandatory in-person mediation. Let me bring that up here. Lots going on in this case. This is all these filed by the judge. Order directing mandatory in-person mediation. Before the court is the court's motion to refer the parties to mediation. This was the court's motion. The judge suggested this. The court, during December 15th hearing, discussed the concept of referring parties back to mediation. The court has now ruled on all post-verdict motions and will soon be entering one or more judgments. The court anticipates plaintiffs to file a motion for costs, and if there is a legal basis, a motion for attorney fees. On the court's own motion, the court directs the parties to mediate all motions for costs or attorney fees, or both, as well as all disagreements existing between them. The court anticipates the parties may need at least 2 separate mediation sessions. two sit-downs with a therapist. That's what we need. The court will leave it at the parties and the mediator to determine the second day of mediation, if the second day of mediation is on the day immediately after the first day, or if some other interval is best, such as 1 week after the first day. The following conditions for mediation must be observed. The mediation must be in person, not via electronic means. For plaintiffs, both Maya Kowalski and Jack Kowalski must be present. The personal representative's attendance is sufficient to represent Kyle's interest because he's a juvenile. Nothing in this order precludes Kyle from attending the mediation. For defendant, Johns Hopkins All Children's Hospital, either the president, chief executive officer of JHATCH, or a senior executive of JHATCH who directly reports to the president, chief executive officer must be present, as well as any other client representative JHATCH elects. Basically, we need a decision maker in here. Let's see. So this is about a 14% reduction. Is that what it came to? It goes from 261 down to 212.5. So that sounds like it. Let's see. Nothing precludes senior executives from also attending, and if attending JHATCH, what's this? Johns Hopkins HSC. Johns Hopkins Health System Corporation. That's the parent. That's the parent company, I believe. We'll be covering the mediation privilege. The court strongly encourages what do we call JHHSC? I don't know. You guys think of how we pronounce this. Attendance. It may assist with settlement discussions. The court does not believe they filed a motion for attorney's fees or costs following its dismissal from this case. If correct, the court understands and acknowledges that JHHSC would no longer be a party, and thus the court would no longer have jurisdiction over them in this proceeding to require them to attend mediation. They're welcome, but it's voluntary. Another requirement, a high-level representative of each insurance carrier or entity operating like an insurance company that may have liability to provide payment for any portion of the impending judgment must attend. This representative must have full authority to resolve the case up to the face amount of the judgment plus accrued interest, or if that amount exceeds the policy's limits, up to the face amount of the policy limits. Critically, this representative must have this full authority without the need to contact any other person or to consult any committee. We want the decision maker there. To be clear, this attendance requirement includes any excess carrier or any entity that operates like an insurance company. If there has been an allegation of bad faith with respect to insurance coverage, the carrier must also have separate counsel and separate representative present during mediation to address and resolve any bad faith claims. Each party shall disclose the identity of each person attending mediation, as well as their role, as well as the requirements of Rule 1.720, at least 20 days prior to the first day of mediation. So mediation will not happen for at least 20 days. I mean, they've got to submit this. You get 3 weeks notice. The attorneys for the parties may jointly agree to invite other persons or entities to be present that the attorneys believe whose presence would be helpful to resolve disputes. Note, both plaintiffs and defense must agree to invite the other persons or entities unless specifically identified in this order. No side may unilaterally invite other persons or entities to attend. This is an invitation only, and both the bride and the groom have to agree on which guests are going to attend. If any such person or entity who is jointly invited agrees to attend the mediation, such person or entity will be covered by the mediation privilege. The first day of mediation must occur on or before April 15th. Okay, so there's our date. We have 1 month. 2 months, sorry. The mediation must be concluded no later than May 13th. The court, at the request of one or more of the parties, may extend this outer deadline. However, this deadline can only be extended by court order and not by agreement of the parties or declaration of the mediator. The parties must jointly select their mediator no later than 10 days from the date of this order and must file a notice of their selection in the court file. If the parties do not select a mediator or file a notice of selection, the court will proceed to appoint a mediator. One more quick one, and this is going to get us to the sanctions, to the issue of sanctions. Last order filed by the judge just went live today. Let's see. Let's go full screen here. Order concerning outstanding sanction requests. As discussed during this December 15th hearing, there are a number of pending unresolved motions seeking various sanctions against a party or attorney or both, as well as unresolved matters in which the court previously awarded entitlement to sanctions but has not yet finalized the sanction award. Collectively, outstanding sanction requests. The court also advised parties that if the parties desired to adjudicate the outstanding sanction requests, the court would conduct the necessary evidentiary hearings following entry of judgment. The court's judgment, in this case, will contain a specific reservation of jurisdiction to address the outstanding sanction requests. Within 15 days of the date of this order, each party shall file a list of all outstanding sanction requests, including the DIN as to each motion or unresolved sanction order. Failure to include the identity of any outstanding sanction request in the parties list will constitute a waiver of that specific sanction request. The judge is asking for a complete list of all grievances. Bring me a list of everything, and not just that. I want proof. I want screenshots. Show me the receipts of when you complained about it first. Okay, give me the DIN number, the motion. I want to have everything in front of me. And if you fail to give me the motion number, and you just say we're also don't forget about this, we're going to consider that waived. By separate order, the court is directing the parties to mediate all outstanding matters. In addition to timely filing the outstanding sanction requests as directed by this order, if the parties wish to pursue the outstanding sanction requests following mediation, the parties will notify the court's judicial assistant of that fact along with a suggested amount of time necessary to adjudicate each such pending sanction request. To be clear, the court will not address the outstanding sanction requests before the mandatory mediation. So sanction comes after the mandatory mediation. If the parties elect not to pursue the outstanding sanction request, the court requests the parties to advise the court's judicial assistant of that decision as well. Done and ordered. And copies sent to everybody. All right, that takes us through the 4 motions. Wow. The big thing, the J. Hatch wanted a new trial based on jury misconduct. That order has been released now, basically saying, no, it's not going to happen. We knew that order was coming. We just waited for the print version. That came out today. The order on post-trial motions, also from the defense, basically everything was dismissed. There's nothing really left there. Directing the mandatory in-person mediation, everybody has to show up. But the big one, and then the sanction requests are going to be handled later. But in the post-trial motions, that's where remitter got included. And the judge did it. He's done. At 12% interest, remitter is about 2 years on the clock before we get back to $261 million. They could sit on this for 2 years before they're over what the jury originally awarded. Nikki, no sanctions yet. The judge has said, give me a list of all your grievances. Every complaint you have against the other side that you want them to pay the price for and me to rule on. Witnesses who have counsel are ordered to talk to the judge, and he states counsel will not allow attorneys to participate during questioning. Goodman Law Firm is keeping a running process of what's happening on the Murdaugh trial. Sorry, let's see if I can find my mouse here. There it is. I think they're in a break right now, right? I think the Murdaugh trial is in a break. I'm only seeing this right here. So. Sounds like a conference room. All right, Judge Carroll stuck a fork in it. He is done. When would interest start? Melissa, it sounds like he has not yet made that order. I believe what has to happen now is the plaintiff Jack and Maya, because Maya's now an adult. She has a different role now that she makes her own decisions. But the plaintiff now has to accept or reject the remittitor. So there's going to be a little bit of time to decide this. Brief recess in the Murdaugh hearing. Lots going on. We're going to take a brief lunch eventually because we've got a break in the trial. The jury's not going to show up in the trial that we're watching. We're talking about this one right here, the Key Lime Key West trial, the Treehouse murder. The jury's not going to be until 1 o'clock Eastern time. So we've got an hour and 45 minutes before that happens. Murdaugh trial is moving forward. Nicole, are you able to give a call? Are you able to call in? I'm not sure if you're listening to me or to the other one, but I'd love to see if somebody could just give us a breakdown, a synopsis of what happened in the Murdaugh issue. Also, let's see, Rob's stream tonight with Mr. Anderson. I'm sure they're going to be talking about these motions for sure. They'll definitely be addressing the remittitor and that amount. Let's see. Let me do the math. Let's do it like this. Hey Siri, what is 212.5 divided by 261?
It's approximately 0.8141.
So they're left with about 82% of the verdict. Is that right? Is it an 18% reduction? Did I do that math right? So remittitor only happened on a couple points. It was sizable. I mean, that's a big difference. He took off $50 million. Let's see. How difficult will this make it for Jay Hetch to appeal? Has Judge Carroll effectively headed them off at the pass? Ms. Violet, I think he's done a very good job of making it difficult. He's documented everything, every step of the way. Everything they've complained about, every issue they've had, every complaint. He's got all his paperwork in a row, and he's been very consistent. And so I think it would be it's very tough to get an appeal granted on this one, I think. 18.5% reduction. That's sizable. That's really is sizable. I think we'll redirect over to Megan if she's going to cover these documents in full during the lunch break. Just want to see if we can cover and get an update on a couple of the other cases. Has anybody been watching if Sarah Boone has appeared in court? It's probably going to be a very brief hearing if it is. I'm not even sure if there's going to be cameras there. But let's see. If we have an hour and a half break on Treehouse and Murdaugh's back in a few, let me call after it's done. You want to call after the break or before? You want to call while they're in a break? My question is, do you want to call right now and just give us just a quick, it doesn't have to be play-by-play, but just let us know what's happened. If someone's been watching that. I appreciate you providing the text breakdown, as we can only watch one thing at a time. Lil Miss says, it's so cold in my house because my furnace can't get up to temp. It's set at. Even Demon Puppy can't get out of bed. Oh, Little Miss, that's not good. Is there someone you can call to see if they can get that addressed? That's really, really chilly. They reduced it by 80 million? Did I do my math wrong? I thought we had 26 plus 16 plus 5 plus $500,000. Let's see who's on the phone here.
Call from, it's Nicole.
Nicole from
Hi.
from Goodman Law Firm. How are you doing, Nicole?
I'm well, thank you so much for asking. How about you?
I'm doing fabulous. It's been too long since we've talked. Are you staying warm and dry over there in California? Nevada.
Not in California. I'm
Nevada.
in the potato country.
Idaho.
Yeah, and it's 1 degree outside. We're supposed to go down to -3. We got 2 feet of snow over last weekend, and we're supposed to get more snow on Wednesday. So, yeah, it's pretty crazy.
So the cars are parked, and you're out on the snowmobiles. Is that the plan?
Pretty much. They haven't even plowed the streets. It's that bad. So.
Wow. I appreciate you keeping an eye on the Murdaugh trial today. Obviously, that's a huge one. For a catch up, can you tell us the case and what the hearing is for, what the allegations are, and what happened today, just sort of all in a nutshell?
Sure. I'll give you a quick breakdown. So after the verdict, obviously they filed a motion with the appellate court saying that there was juror misconduct and, it had to go back for a new trial hearing. So the appellate court granted Murdaugh's motion and remanded it back to the trial court to decide whether or not there's a motion for a new trial. The judge, after that, recused himself from the case. So he will not preside over any hearings on the case.
This is Judge Newman.
So the new judge has been appointed, and so essentially the motion that they were arguing today, or the positions that they're arguing today, so this is sort of pre-motion. The motion's on the 29th, or the hearing's on the 29th for the motion. They're arguing what they can do on the 29th. So the court argued that his focus is going to be whether or not the jurors were improperly contacted by the clerk and whether there was any influence on their decision. He's not going to get into a bunch of extraneous stuff like the clerk's son's wiretapping charges, or that she was found to have been using her office for improper gain. So there's some things he's limiting, but essentially he's going to allow jurors to be questioned. Those jurors that have attorneys, he's essentially saying, I'm not going to let you interfere with this process. And and so all the jurors were interviewed by video with SLED. The clerk was interviewed but refused to be videoed, so there's a memorandum of interview. Essentially, it looks like she had this communication. I know she denied it, but from what the prosecution said in her memorandum from SLED, she did. So yeah, it's really interesting. It's going to be interesting. Now the court is going to do the questioning, but the court said, because the defense wanted to present all the videos from SLED and additional, email communications that were going on during the trial between, jurors and the clerk and the prosecutor and all this other stuff. So the court's going to take some of that into consideration, but he's not going to allow the prosecutor and the clerk's communications to be discussed, and any communications between the clerk and SLED or anything like that. He's focusing on whether there was, influence on this jury. So he's really limiting it. Now he's doing that on a case called Green. They were trying to the burden of proof is on the defense. So that's why these witnesses are being called this way, and the court's doing the questioning. Now, if he had followed the case Reamer that the defense wanted him to follow, the prejudice would have been presumed, and the state would have to prove through questioning there was no misconduct, and it didn't influence the jury. So the burden shifting is sort of a big deal, because now the defense has the burden to prove whether or not the jury was influenced, as opposed to the state proving that influence or communication was harmless, and it didn't have any impact. Pretty cool. But I think that this decision is going to go up on appeal, because the way and the cases that the defense were arguing, even the prosecution was discussing, seems like the judge is following the wrong case. Just real quickly, Green had to do with juror communications regarding the substance of the trial. And that's why the court ruled, the appellate court or Supreme Court, I think, ruled that it was presumed, right? And the Green, that was the Reamer case. It was presumed. The Green case said that communications between the bailiff and the jurors, and that communication was, if you guys don't come to a decision, the court's going to give you, Allen instruction. The court said in that case, there's a burden to prove whether or not that communication influenced the outcome of the case.
Interesting.
So in Reamer, it was presumed because it was on the substance. Now, this communication was on the substance because the clerk's alleged communication is that Murdaugh's lying, essentially.
Yeah. So basically, the whole premise is that the clerk influenced the jury to make them make this decision to find Alex Murdaugh guilty, and had it not been for her,
improper contact. They have to prove improper contact. So she actually had the communication, which it looks like all the affidavits essentially say, except for the one that's taking the fifth, which is so crazy. I mean,
a juror's pleading the fifth.
That's an admission.
Yeah.
So, and I hate to say it because it's not supposed to be, but if
you can only plead the fifth
influenced,
if you had a way, something that would jeopardize your position, right?
That's right. I mean, if you're a juror and you did nothing wrong, why would you take the fifth? But anyhow, but you have a right to. So it's whether or not there was improper contact. That's step one. Step two is whether or not there was influence based on that contact. Now, that's not just with the juror that was influenced, but also whether that juror went to other jurors and whether those statements influenced other jurors. There's also an allegation that the clerk talked to the foreperson, which is also kind of crazy. So they're going to get into that too.
Why?
But when we get back from the break, I know.
So
apparently she told her assistant that she wanted a guilty verdict because it would be better for her book sales. Yeah. So the defense is arguing that that's the motive for her improper influence on the jury, is that it was that she wanted money.
If all this is true, this basically means new trial, right?
Yes. Oh gosh, yes.
So it sounds like it's just they're going through the formalities now of reaching that decision, which means we've got Alex Murdaugh. He's pled guilty to the financial stuff.
We're back.
Right? You're back. Okay.
We're back. Yeah, we're back. I'll call you after.
Thanks a lot. Thanks for keeping us up to date.
Bye.
All right. Bye.
Yeah. Bye.
Man, it's getting crazy over there in the Murdaugh trial. It sounds like we're going to get Murdaugh version 2. And it's going to be the murder trial, not the financial trial, because he's pled guilty to those. So I don't even know if they're going to bring in those financial things as much at all in the second trial as they did in the first one. But if they do, it's going to be, I think, much more condensed. But wow! Be back soon. This is good and long. Okay, so here's what we've got going on. We've got an hour and a half before the jury comes back in this. I know Megan Fox right now is handling this. Emily D. Baker, if you're interested in the Murdaugh trial, she doesn't let me transfer. I can't redirect. I need permission to redirect to her channel. But Emily D. Baker is discussing this Murdaugh issue. She's following that trial. If you're very interested in what's happening with Alex Murdaugh, she's doing that right now. Also, Megan Fox is reading through the motions that we just read through, and you can get some breakdown of that with her very unique style and spin, and we're going to redirect to her channel during our lunch break. We've got an hour and a half lunch break. You need a book. You keep wanting me to use other cameras constantly. Which book do you want? Okay, so this camera's live, so you might. She's so close to the camera. She's going to bump it here in just a second. All right, love you, Mrs. R.A. All right, so we're gonna go over there on lunch and let you listen to some of that and listen to that take as I sort of breezed through a lot of them. Brandy's going to be on as well. I have not heard from Sarah Boone yet. I know there was a Gilgo Beach update that happened today. We have not even dug into that at all. So there's a lot to cover. If you guys want to do some digging and let me know. Let's see. Oh, Legal Vices with Megan and Hippo Lovers in chat. Sounds great. That might be a fun place to go visit. We're going to pop over there in just a second. Brandy for lunch is also a great destination. I think she's got a court case she's following right now. We're going to be back at 1:00 with a continuation of the Key Lime, Key West Treehouse murder trial, which is gotten a little spicy. The judges were very upset. We had a defendant once again who was late to court. He brought a doctor's note, but the judge was not buying it. We've got a lot of education that's been going on with the defendant to try to help him get up to speed as to what he needs to do and what is allowed in court. But this is crazy. So that's going to be an hour and a half. We're going to be back at 1. Well, we're going to be back in an hour and 15 minutes. That's a regular lunch time. Counsel's conferring right now on Murdaugh. I'm going to keep an eye on that during lunch as well, because that does interest me. I'm going to be watching like 6 different things, right? So here's my view. You can see I've got Murdaugh going. I've got to get Emily D. Baker pulled up on one of them. I think I'd want her spin on that. Also, we're going to be going to all that. Brandy, everybody, you guys. I need to hit this button. There we go. I should have done that about 30 seconds ago. Do you want more devices? Greeners, I need more devices. I think I've got a laptop over here. I'm going to have to use our counter iPad. And then I just need to have the ability to consume all that audio at the same time. That's it. Whoa. Little explosion there in the middle of the song. This is the Super Bowl of true crime today, is what's happening. It's anywhere you go, we've got stuff to talk about. Jules is giving me a call. I'm going to take that off the air in just a second. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live. We'll be back at 12:45, so an hour and 15 minutes with the Treehouse murder trial, as well as we're keeping an update on everything else. Hang on 1 second, Jules. Just 1 second. Jules, I've got you muted. I'll talk to you as soon as this outro's over. So yeah, we're going to be back here as always. First person in chat wins the internet. If you want that to be you, just click the subscribe button and ring the bell. We're going to be back this afternoon, and we'll be discussing all these things. Might even be jumping in and taking some highlights from those other events that have happened throughout the day. So whether you go to Brandy or Megan Fox, I think we're jumping to Megan Fox right now. Emily D. Baker, Kurt's live. Basically, everyone is talking about something in court right now. Remember how the year started and there was nothing to do? Well, we're over that. It's past. That's in the past. Buckle up. It's going to be a great year. You guys have a great lunch. We will see you on the other side. Bye-bye.